Yes, sir.
My Lord, I am challenging the order of Leonard Kate at page 89, my Lord. Order dated 26/9/2025.
Will issue notice. Issue notice. Learned DSG, Mr. Padi is requested to accept notice for OP number, all OPs. OP number 1 to 5. Notice to 6 is dispensed with. You give copies.
My Lord.
Next.
Item 2, review petition 86 of 2026.
Yes.
Speak kindly.
My lord, they have just served the copy on me. I've just received the copy. I'm
In the
preparing.
first week of May we have. Because she has.
Yes, I have absolutely no. The problem is your lordship granted time till 24th. I have deposited the first installment because within the time that 24 lakhs I have deposited. The only request to lordship that because my government said on behalf of the bank, the total amount comes to 2 crore.
No, whatever argument you are doing,
Sir.
you can do it. But unless madam reads the papers, she will not be able to answer you.
Because the 24th is going to expire. That is, I have absolute no objection. Absolute no. Yes. 24th. Because your lordship remember that both Mr. Rao and myself have made a mention on 10th. Because within the time I must complete your lordship's notice. Any date also I have no problem. But let us also take because bank also want to realize. I want to also.
24th. Post this matter on 24th.
My lord, only one, I'm just going through this petition. I may take you to page 12.
Are you ready in the matter?
No, my lords. This is something not, my lord, just 1 minute. A personal communication between me and the filing counsel of the petitioner has been annexed as a WhatsApp message. It's totally unethical, my lords. I'll file a report. It's totally unethical and immoral. Unethical and immoral, my lords.
About this case, because we have. I'll address.
And from 2 senior counsels not expected.
See how senior counsel will know. He is not, senior counsel are not expected to draft the pleadings at all. They are
Yes,
going to settle the pleading. That's
Yes,
all. Drafted. So therefore, now say, what is that, brother? Who? You have done that?
He's the associate of,
You give it. Which is that, please?
my lord, page, annexure 1,
Give that.
page 12.
This is, see, WhatsApp, so many things we do.
No, it's not.
Everything is put
The
together.
contents are, I don't mind, my lords, if my,
No, not like.
I merely said, please approach the bank for the statement.
The entire communication, as I have understood,
No.
absolutely, your lordships are right. What I'm trying to say, the entire communication as annexed, I have also seen, is that my land friend said that she will serve a copy of the accounts in course of the day.
Whatever.
That was not done. That was not done.
But can the client sign the affidavit saying this is the correct?
I stand aware, But
You remove that. You remove that.
No, that's right. I also have told them. No issue at all.
No
issue at all.
Panel counsel appearing for the bank points out that the document at Annexure 1 at page 12 of the pleadings is a copy of the WhatsApp interaction between herself and the advocate representing the
petition.
Who is that? Petitioner borrower.
Yes.
Petitioner borrower. First off, she very strongly objects for making the said document through communication part of the record, and we agree with that. First off, the learned senior advocate appearing for the petitioner on instruction of the advocate on record very fairly agrees with the proposal of the court that this document should be eschewed from the records for all purposes. First, registry to mask this document completely as if it is not part of the record, and a copy of that shall not be given to anybody in any circumstance. Next.
Item 3, WBC 8935 of 2026.
Another review, I have also filed.
So do that.
No.
Call this matter.
Along with 87.
That's all.
Review petition number
Write down, Mr. Law, write down. Call this matter along with you. Okay.
May I please, Your Honor?
Number 3, my lord, here the
Dear my lord, I have instruction to appear for the sole OP, my lord.
So OP,
My lord.
you're for the OP. What is this matter about, brother?
here the Provident Fund organization has compulsorily retired one of its employees, was an enforcement officer, and
Why
again
your client is standing there?
No, she not my client.
Madam, what do you want? What do you want? Why are you here?
She's item number 4, my lord.
Item number.
Which item?
Kindly wait.
She is in
We'll call you
person.
wait.
He is in person. In person. All right.
Sit down, sit down. Yes.
Lord, one of the officers of the Employees Provident Fund organization was an enforcement officer, and against whom, my lord, a criminal trial is pending pursuant to a CBI trap case, and a departmental inquiry is, my lord, pending. He has been given compulsory retirement. In challenging that order, he has approached the Honorable Central
That has
Administrative.
been set aside.
That has been set aside, my
That
lord.
is set aside because of another order by Jabalpur bench.
Where, my lord, in that case, in those cases, my lord, in the principal bench and that Jabalpur bench, my lord, there the criminal trial, he has been acquitted. So actually, it's completely different, my lord. And
It was
by
a case of acquittal.
yes, my lord, and that is this is, my lord, trial is pending, my lord.
Trial is pending.
No,
And in both.
What if you-
Sorry, ma'am.
Well, that's on the record on it's the
No,
trial
he's
is pending.
saying no to your version that trial is pending.
Well, that's what I'm
Let him-
surprised.
If he shows that
Yes,
there is no
yes.
trial, then you are okay.
Already.
Yes,
My
lord.
lord,
Judgment is
If he
already there.
acquitted.
Roland Tribunal relied upon an order of Kotak bench, my lord, where trial is going on, and after order of Kotak bench, the department challenged the same by filing any writ application before, my lord, and the same had already been implemented, and I had also filed the complaints report along with my region before the Roland Tribunal, my lord.
Repeat.
The OA number relied upon by Roland Tribunal.
Way which is that way.
336 of 202.
Apart from Jabalpur bench.
There are
Yes, my lord.
three
Bench, my lord.
three decisions have been relied upon. Page 28 towards the bottom, OA 336 of 2023, that has been
You can
quoted.
also kindly give glance page 13 of the impugn order, my lord.
1-3.
1-3, my lord. Of the impugn order, running page I cannot see because I am not
Running
holding
page
that
28, I'm just assisting. Running page 28, my lord.
Running page 28. You have
Right.
not numbered the petition.
My lord, it has appeared on, my lord, no caveat has been filed, so I have not solved the copy.
So the three judgments there, 4 judgments.
My lord, first is the relevant portion of the order dated 3/12/2024 of this bench passed in order number 336 of 2023. In that case, the long time relied upon 2 orders of other benches, my lord. So far, the order passed in order number 336 2023 is concerned, that has been implemented, my lord. Without any challenge.
Whether that 336 of 23 was not challenged.
No, my lord, complied with.
That has not been challenged.
Then what remains?
My lord, here, there in 336, my lord, may I just have this? Now, in 336, there are 2-3 things, my lord, which are distinct from this case. The appraisal report of that officer and the integrity report different from the present case. 1. 2, my lord, in that 336, the learned tribunal has relied upon 2 judgments of the principal bench and Jabalpur bench, where, my lord, there has been acquittal in the criminal case.
So the fact matrix did not match.
And, my lord, just by quoting that 336, and at the end of the quotation, we did not find any reason to deviate from the opposite order. So there has been no discussion on, my lord, how that subjective, my lord, satisfaction of the employer, how, my lord, that is either tainted with malafide or arbitrary, that has not been discussed with, and just by quoting that order, we are in agreement, hence the order is set aside.
It is FR 56J.
Jail, my lord.
Required
And-
consideration.
And
Because of the latest judgment of the apex court. Not latest, 1 year old judgment. It requires consideration.
so, my lord,
You
my-
accept notice. We'll hear this
I will
matter.
take notice. Well, my only submission before my lord is
No, that cannot be.
order cannot be punitive, my lord.
It cannot be
Punitive.
punitive.
Because
Suppose
they
it
retire
would-
me compulsorily. So being an employee, I am entitled all benefits.
no,
While
sir.
issuing that order,
Once.
they have said that
Once.
my all benefits subject to outcome of the criminal proceeding pending before the court below.
Brother, now there is a compulsory retirement under 56J. Is it not? A compulsory retirement cannot be a punitive order. It is a retirement without stigma.
That's the settle.
If it is a retirement, then he is entitled to all the terminal benefits. That's all. This will make clear. If privacy, if you are compulsorily retiring me as a punishment, that is another thing.
I got
This is
it.
not by way of punishment.
No.
It's a way of punishment.
No, man.
No. 56J
That's settled, my lord. What is
Yeah.
calling from my lordship?
Ah.
If my learned senior is agreeing to that, my lord,
will make
just
objection against further.
one, my lord, opportunity to take instruction on that. It can be
What
fixed,
is section?
my lord, on that point.
56J.
Record, where is the
56J.
So far as
It's
that-
not stigmatic.
My lord,
That is
that's
your
settled,
case.
my lord.
Then we will say whatever has been said that casts some shadow on his character, integrity, not character, integrity. We will say that will not have that meaning. The order of compulsory retirement shall be construed by one and all 147 crore people of this country. That is not punitive order. With this observation, we can dispose of, subject to outcome of the criminal proceedings. If the criminal proceedings something happens, then there are some rules. There are at least Thangapadu versus State of Tamil Nadu. There are where you can have recourse to those things. With that observation, we dispose of the matter. You want to consult your point? You accept notice now. We call this matter week after next, in the first week of May. But I don't understand really. How will you be agreed with our
my lord,
because rule itself says that.
But just, my lord, as a, my lord, counsel appearing, my lord, I'm
Issue.
the agreement with this, my lord.
Issue notice. First time. Learned counsel Sri so accepts notice for the OP, sole OP. First time. Matter lies in a very narrow compartment in the sense that the provisions of section fundamental rule 56J have to be construed, and it is not it is no longer res integra in view of decisions of the apex court. First, therefore, call this matter in the second week of May. With that clarification,
Copy of the
yeah, you
My lord, that I'll,
copy, paginate it properly.
my lord, that I'll give.
Yeah. Next.
Item 4, WBC 9179 of 2026.
Memo to withdraw. Memo is filed by whom?
This not file an application to set aside the possession notice issued by the opposite person or
What
what?
is this memo for withdrawal? Who has filed this?
Petitioner is interested with them.
Petitioner has filed that. You, what's her name?
Because in the meantime, my lord, the property has been sold, my lord.
You are for the petitioner.
Bank, my lord.
Bank. And madam appears party in person.
Here is the petition.
You want to withdraw this petition? You have filed that memo.
withdraw କରିବାକୁ ଚାହୁଁଛନ୍ତି
And allowed to liberty for challenging this.
Go before the DRT. And will exclude the period spent before the court. Because otherwise limitation should not come in the way. Challenge is to the coercive proceedings of loan recovery constituted under the provisions of the Surface Act 2000. First off, after service of notice, the OPs have entered appearance through their panel counsel. Both your panel counsel?
Yeah, I know.
I am the petitioner. Advocate of the
She said
petitioner.
the parties.
Party is also.
Party is also interested.
And the rest is the petition. Counsel for the petition, OP points out that against the action of the kind, recourse can be had, redressal can be had at the hands of the DRT as provided under section 17 of the Act, correct?
Because in the meantime,
I'm asking, is it correct, madam? 17 of the Act, comma. In the meanwhile, the property having been auctioned, first one. Next, we do not find any extraordinary circumstances to grant interference in the bank. First one. Next, rightly, the petitioner party in person, who is now assisted by Shri so and so, okay, have filed a memo dated 20 April 2026, seeking leave of the court to withdraw the petition. First one. Memo reads as. Next paragraph. One sentence. There is no objection from the bank side to the proposal. Next paragraph. In the above circumstances, petition is good option as having been withdrawn with liberty to work out the redressal, have the redressal elsewhere in accordance with law. First, in that connection, all contentions of the parties are kept open. First, next paragraph. It hardly needs to be stated that the period spent in prosecuting the petition is liable to be discounted under Section 14 of the Limitation Act 1963 while computing the period of limitation for approaching the DRT or such other authority as the case may be. Next.
Item 5, WBC 9454 of 2026.
Maybe.
Yes.
Milord, it's a home loan, Milord. Outstanding is Milord 6,31,401 Milord. As on 30th of January, Milord. The 30th of 2025. Milord.
Yes, waste papers. Where are the waste notes? Yesterday we used it. Don't you anything last week? Give us right? See that page is like very often. Yes, sir. Loan was taken when?
Milord,
Item 5. On behalf of Mr. J. Swai, I am for the Capital Bank.
Yes. What is the loan amount?
loan amount is Milord 6,31,401 Milord. As on 30th January 2025.
6,31,401.
401.
As on
Milord 30th of 2025.
50 Jan 2025.
Yes, Milord.
What was this loan about?
Milord, it is a home loan.
Home loan.
Construction of a home, Milord. The petitioner taken loan of rupees 6 lakhs, Milord.
How much you have paid?
Milord, I have paid Milord regularly. Milord, I am paying the EMIs. Milord.
EMI you are paying?
Yes, Milord. Since because 3 months EMI has not been paid, that is why Milord the loan became NPA.
Yes.
And 13
NPA was
NPA was Milord on 4th January 2025.
425.
Yes, Milord. Thereafter Milord 13 to notice issue. I responded Milord.
32 is when?
13 to Milord by Annexure 1. It was issued Milord on the month of January, 30th January 2025. 30th is. Thereafter Milord 13-4 notice was issued Milord.
13-4 was dated?
It was Milord 10th of April 2025.
Now what is the position?
Now the position is standstill, Milord. Now, Milord, in the meantime, Milord, bank has approached the London CJ, Milord, under Section 14 of the SAPESI Act.
14 is press now.
14, Milord, the order was passed on 27th of February 2026 by Annexure 5P.
But against that you have a redressal.
I have a redressal, Milord, but Milord, since because it is a small amount, and Milord, sale notice has not been published, and as per the decision of the Honorable Papist Court and this Honorable Court, Milord.
Got that 9-point affidavit.
Milord, no, Milord. When this sale notice will be issued, Milord, right to redemption is not there with me. So now, Milord, sale notice has not been issued.
It is
in the meantime, Milord, for 1 second.
6,31,000.
Milord, in the
6,30,000. When the
one submission.
is a remedy under Section 17 of the
We told him now.
Yes, Lord.
Now we are asking you, it is a home loan.
Yes, Lord.
It is a paltry sum of 6,31,401. Maybe
Yes, Lord.
little more now because of lapse of 1 year. 1.5
Lordship, just a minute, right? So the outstanding amount against the loan account is 7,15,000.
7,16,000.
15,000.
16,000. We'll say 1,000 more now. You want to sell the house? Take the possession. No, we will not permit it. People will lose faith in the constitution. Let him pay.
1,50,000 Milord I have paid on 15th of April, Milord.
You have paid now?
Milord, during pendency of this application, Milord.
Yes, he has paid 1,15,000 for a settlement. That is approach the
You accept that money, appropriate to the loan account. We will give him reasonable time. Within that, he will.
Milord, I will pay.
Thousands of crores who have eaten, they have gone abroad and no action is being taken by anybody. 6 lakh, 7 lakh, etc. What is this, brother? No. They're all poor people. It's a housing loan. After all, if they do not do, you can sell the property thereafter. You can't take a sledgehammer at this stage. No.
1 week time to obtain instruction.
No.
We'll give, but don't take any action. We'll give you 2 weeks. Issue petitioner. You 1,50,000 you have paid on which date?
My lord, on 15th April 2026, my lord. I have deposited in the bank, my lord. This is the receipt, my lord.
1 lakh or 1,50,000?
1,50,000.
1.5.
No, 1,50,000.
50. That's right. 1.5. Now remaining amount, when are you going to?
My lord, your lordship, kindly give me some time, my lord. If
What is
50,000, my lord, my instruction that, my lord, recently, my lord, I have 50,000. I will pay, my lord, within period of 1 week or, my lord, in between.
No, 50,000 is now 1.5 you have paid.
Within a week, my lord.
Another 50,000 you pay within 1 week.
Yes, my lord.
Remaining amount you pay within 3 months.
As your lordship direct, my lord, kindly give me a little more time since because I am also suffering, my lord. I will pay the amount, my lord. My lord, because
you want money,
that's
okay.
Yes,
Or you want property. No, there is such tendency nowadays we are seeing. Somehow they want to ensure that the property is sold for a song. Not in this case. Now he is agreeable. 1,50,000 is paid. 50 again he is adding within 1 week. So 2 will go. Out of 7 lakh, 15,000.
Yes, Lord.
Then for remaining amount, that is for remaining amount, that will be 5.5 plus. 5 some, that's all. 565.
Yes, Lord.
For that money, we will give 3 months time. Okay?
little more time.
Is it?
I will definitely, my lord, I will pay, my lord. Yes, my lord.
Within 6 months, you
6 months.
and interest will go on.
Yes, my lord. I will pay.
8 months. Petitioner can be seated. A borrower was due in an outstanding amount of rupees 6,31,401 by way of housing loan as on 30 January 2025. And now it is stated to be 7,15,000 plus.
Yes, Lord.
As per the learned panel council appearing on AVN for the bank. First, the loan account was certified as NPA on 4/1/2025. Since 3 of the installments that had fallen due were not paid. First, this was followed by notice under section 13(2) dated 30 January 25, eventually resulting into the possession notice under section 13(4) dated 10/4/2025. First, all this is under the provisions of the Surface Act 2000. First, as the things would happen in due course, the bank secured an order at the hands of learned CJM
Jagat
Singhpur on
27 to 2026. Order dated 27 to
27 February 2026. 20. First. Next paragraph. In the meanwhile, thereafter, the borrower has remitted a sum of rupees 1.5 lakh
on
15/4/2026 with instruction to the bank to appropriate the same to the outstanding amount.
Yes, Lord.
Loan amount.
That has not accepted.
Bank has not accepted.
He has paid 1,15,000 on 15/4/2026.
That is what.
That amount
1.15 or 1.50.
50.
50.
You have to accept them. Unless there is one provision in the contract where the borrower makes the payment unless there is a contra provision, that amount should be appropriated to the principal amount. But generally, under the banking rules, with Conditional mentioned, we have written liberty to appropriate to the costs or interest and then to the other things. That is there. We will not say anything. You accept that. Bank is yet to formally accept the SEDA. First time. Next paragraph. Learned panel counsel appearing for the caveator bank opposes the petition, saying that the petitioner has got an alternate remedy which is more efficacious than the WP as provided under section 17 of the 2002 Act, and therefore be relegated to that remedy. First one. Alternative remedy cannot be, in matters like this, cannot act like a China wall, Great Wall of China, between the court and the person who has brought a worthy cause to its court. First one. Justice has to be individualized, keeping in view all circumstances. First, this is how the apex court in a category of decisions has construed the doctrine of alternate remedy. First, next, having heard learned counsel for the parties and having perused the petition papers, we are inclined to grant conditional review to the petitioner, since it is a housing loan and that he has shown bona fide by housing loan of a small amount, stated to be 7,15,000 plus. First off, added, he has shown bona fide by remitting another sum of rupees 1.5 lakh on 15 for 2026. First off, he also assures the court that assures the court that another sum of rupees 50,000 would be remitted to the bank within 10 days from this day, and that if a period of 6 months is granted, the entire loan amount would be repaid with the interest accruing thereon in a normative. First, all this makes out a fair case for the interference of the cause. First, a writ court cannot send back worthy litigant empty-handed by quoting some jurisprudential theories. First, that is not the object for which our constitution has established the high courts. First, next, in the above circumstances, this petition having been allowed, we make the following directions. 1. Roman 1. The amount paid by the petitioner in a sum of rupees 1.5 lakh on 15 for 2026 shall be appropriated by the bank in a normative way in respect to loan account. Immediate. First term. Petitioner shall pay another sum of rupees 50,000 within 10 days. Next one. Petitioner shall repay the entire loan amount along with the interest accruing thereon in due course within an outer limit of 6 months. 6 months. This payment should happen in terms of installments prescribed by the bank when a loan was taken, with the additional money to match the 6 month period. All right? Additional, because within 6 months it has to be paid. First. Next, last one. In the event this concession is not availed by the petitioner, comma, the bank may take possession of property in terms of impugned order dated. Impugned order dated
27 to
27 to 2026.
27 February 2026. 26 and proceed with the matter in accordance with proceedings. Yes.
little clear, man. If in between, my lord, any scheme, OT scheme will be available, my lord, for the petitioner by the
Next
bank, my lord, that may be
It is
considered.
not, this judgment will not come in the way of bank entertaining the proposal for OTS in a normative. No question.
Item 6, WBC 9925 of 2026.
My lord,
Yes.
this is a challenge of the act and the notification issued under the act. My lord, the act is eating into the electricity act, my lord. My lord, I am been led by Mr. Sanjay Sen in this.
Copy. Just now I gone through this from the system itself. Let them serve a copy, then I will prepare it.
No, let him make a case first for admission. You are not entered
Yes, for
caveat.
admission.
No, we are not filed caveat, but
Let us-
I got them sub to copy to the union.
No,
Let
we
us
come to
see.
give-
That's me.
We are not passing any order adverse to you at this.
Then
Let us. Yes, sir.
May I make one submission?
Electricity Act.
Yes, my lord, we are trying this matter to be listed tomorrow. We got listed today. My lord,
EC Act and the Electricity Act 2003.
this is Electricity Conservation Act, my lord.
Huh?
Electricity Conservation Act.
Oh, like that.
Energy Conservation Act. My lord, Electricity Act itself is a comprehensive enactment.
yes, 2001. That's what we did.
My lord, Electricity Act itself is a comprehensive enactment, my lord,
Yes, sir.
passed under the concurrent list, my lord, which deals with each and every aspect. And there are two provisions, 173 and 174, by virtue of which the Electricity Act, to the extent it is dealing with various aspects of electricity in the country, it will have overriding effect over all other central and state enactments. Yet, under the Energy Conservation Act, by virtue of an amendment, a provision has been added, and pursuant to that provision, notifications have been issued, which is actually in contravention and ultra vires the Electricity Act under the Electricity. Therefore, we have challenged them.
Outside. An act can be, which Shirwai has mentioned in 4th edition of his constitutional law. An act cannot be challenged on the ground that it violates another act. The procedure for amendment, the challenge is, which Apex Court decided in, which is that famous judgment, Justice Ramakrishna Dalmia versus Justice R.K. Tendulkar. Apex Court, 6 postulates have been laid down. This is what we have been taught in the law school. Maybe there is much of law also, but 4th edition of Shirwai quotes R.K. Dalmia. All right. An act cannot be challenged on the ground that it violates the provisions of another act, except where the state has enacted in respect of concurrent list, which is already occupied.
Repugnancy, my lord.
State of the present.
My lord, I am not on repugnancy. My lord, please bear with me, my lord.
Come to next.
My lord, by virtue of this 14
In code 5538.
my lord,
Come to the first round, we are not impressed.
no, my lord, may I make one submission, my lord?
Yes.
By virtue of this 14X, 2 notifications have been issued, one after another. The subsequent one in suppression of the previous one, which is 2025. This 27/9/2025 notification. My lord, may I just, under the Electricity Act 86(1)(e), the act mandates that there has to be promotion of purchase of power from the renewable energy sources. Therefore, there is a renewable purchase obligation which is imposed upon each and every obligated entity like the distribution licensee, that out of your total consumption, a certain percentage of the total consumption you have to procure from the renewable energy sources so that renewable energy is promoted. So on the basis of that, there are targets provided by each and every regulatory commission. The regulatory commission has started giving target by virtue of which target you have to procure certain percentage of your total consumption. This has happened by virtue of not only 86(1)(e), but under the same Electricity Act, power is vested with the state commission by virtue of which the state commissions can make regulations, which are delegated legislations. Under that, they have given targets. Each and every state has given different target. Now comes central government by virtue of another enactment, whereby the central government is giving target, and it is saying that by virtue of this notification, it will subsume whatever target is given by the state commission in violation. They are taking away the power of the state commission, which is protected, which is ensuing out of another enactment. But please kindly have a look at
No,
the
it's no view at all. This view is rejected by the apex court. Your argument is already rejected by the apex court. No.
My lord, that is you. My lord, there has to be regulatory certainty.
You can't two legislations on the ground that each are restrictive of other. That is not.
My lord, kindly have a look at the Electricity Act, please, my lord. My lord, kindly have a look at the Electricity Act.
We are on the first, sir.
On the
Sir.
very first principle, my lord, that the sanctity of the enactment promulgated by the parliament has to be respected. And my lord, please have a look at the two sections.
You are not
171.
complete the sentence.
My lord, Electricity Act. My lord, please.
It's not completed. You have left it halfway through.
Then there is some connectivity.
No. You said, and you only stopped halfway through. First principle is an act cannot be challenged on the ground that it violates another act of the same lawmaker.
My lord, under the Electricity Act, I'll just make good my case, my lord. Under the Electricity Act, Section 174, my lord, Act to have overriding effect, save as otherwise provided under 173, because under 173, 3 specific enactments have been saved by the parliament. Apart from that, which are Atomic Energy, Railway Act and Consumer Protection Act. Apart from that, it says, may I read, the provisions of this act, which is Electricity Act, shall have effect notwithstanding anything inconsistent therewith.
It has got overriding effect.
In any law. So my lord, my difficulty today my difficulty as an obligated entity is which one to follow. And my lord, please appreciate the state commission, if I don't follow, they have a proceeding. And under the Energy Conservation Act, it is saying that all the state commission, whatever renewable purchase obligation they have prescribed, everything gets subsumed into me without any authority. And you are bound to follow. Unless you follow, there is a penal provision which will be 10 times of what the RCO is. And my lord, please appreciate the state of Odisha. I am running a captive power plant by virtue of the regulation and the notification of the state commission. I am entitled only for a compliance of 3%. That means my total consumption, 3% of that should be through renewable sources. Now, with this notification, it has become 29.9%.
No. Are you challenging the act or are you challenging the notification issued under the act? Be clear on that first.
I've challenged both, my lord. I've challenged both. Please have a look.
Challenge to act is concerned, we are negating it now.
My lord, may I make one submission? May I make one submission? My lord, this particular question, each and every, my lord, may I make? I'm sorry. Your lordship was saying something. I'm sorry. My lord, may I make one submission? This particular issue is being faced by each and every state. The industries in Chhattisgarh have challenged it before Chhattisgarh High Court. The industries in challenged it before Bombay High Court. The industry
will issue notice. Let
Hello.
him and come out with that after seeing Sirvai. Your question is answered.
I'm obliged, my lord, for that particular. I'll also look into that aspect, my lord. I'll examine that.
Senior advocate Mr. So and so appearing for the petitioner. First up, issue notice. How many OPs?
Appeal 1, 2, 3, not
Focus one. Issue notice. First up, learned DSG Mr. Body on request accepts notice for 1, 2, and 3. First up, Orissa Electricity Regulatory Commission.
OESC must have their own. Independent.
Issue emergent notice to OP number 4. OP number 4. First up, post immediately after service. Next.
Item 7, WPC 1.
My lord, there is an IA also. Since there is a demand, my lord, this illegal notification, there is an IA we have filed for no coercive action in the meantime.
After service of notice. And not admission.
May I pray one? I'm accepting only 1 and 3 for 2 Lassime said.
Emergent notice to 2 and
2 and 4.
2 and 4.
Mobilization.
Okay. Next.
My lord,
2026.
Please, Your Lordships.
Yes.
But I'm challenging an order of the Central Administrative Tribunal,
Yes.
which has quashed a revised select panel in which my name was recommended for promotion. Because I'm just handing over a list of dates, short list of dates. On 24th of February, the railway authorities issued an advertisement for holding a selection process for the post of junior engineers. And this is an in-service examination.
In-service for
In-service examination for promotion. And the method of selection was 100% objective MCQ type questions. The
On what ground it question?
Well, it's the tribunal has committed an error apparent on record. And secondly, they have not appreciated there is a ratio, they have applied the ratio of 2 judgments. Bihar Public Service Commission versus Pramod Kumar Srivastava and Himachal Pradesh versus Mukesh Gupta, where the ratio is that in the absence of rules, reevaluation of an answer script is impermissible. Those same judgments say that reevaluation is permissible if there is discrepancy in the answer key or the question paper. I fall into that second category, and that exception has been carved out by the Supreme Court. It is not a case of an individual's answer script being reevaluated. It is a case of answer script of all candidates being reevaluated. Yes, because of a discrepancy. And there is also...
What was the discrepancy?
Whereas there were 5 questions which were wrong, the answers were wrong.
Total number of questions?
Total 100 questions.
Out of 5 were wrong.
5 were wrong. The answer key was not published after the examination was held as per the rules. The answer key was published only after publication of the first select list.
Who had to publish it?
The railway authority. As per their own railway board resolution, the answer key should have been published right after the examination so that an opportunity is granted to all candidates to give their objections. Now, that was not published. I obtained it through RTA after the select list was published. And after I pointed it out to the railway authorities accept my submission. The railway authorities accept that, yes, 5 questions are wrong. We will reevaluate all the answer scripts.
All the answer sheet means 5.
In respect of those 5 questions, we will reevaluate.
For all people.
For all the people. Now, the tribunal holds that in the absence of rules, reevaluation is impermissible.
No, that's not very.
Mukesh Gupta says if there is any discrepancy in the answer key, then the question of all the candidates can be evaluated.
Right. The power to review varies from the realm of academics to the realm of recruitment.
Well,
in recruitment, various other things is important, right from the days of Ghanshyam Das. So, the tribunal comes to a conclusion, there can never be revaluation at all.
No revaluation, even if the answer key is wrong.
No, may not have it.
And I will also point out one error apparent on record.
That.
The rule is in accordance to this individual.
Yes, quite. That is Mukesh Gupta clarifies that specifically. They have read the one paragraph of the judgment of Mukesh Gupta without reading the entire judgment, where an exception has been carved out.
Read that which you want to bank upon. Who appears for the other side? Your appears. That appears to be enough. At least two judgments say that.
But the notice has to be issued to the private respondent.
So in this case, I am appearing for sole private OP, who is the applicant before law tribunal matter.
My notice.
My submission
requires consideration.
My submission before matter that while issuing the revised panel, there was a noting that the revised panel has prepared in compliance to an order rule on a tribunal matter. I challenge the same by filing an application, a counter file. Then a new stand taken in the counter saying that no, only because some candidates made a representation, we have revalued all the 210 OMR seats. Then I find there is no such provision. Then say no, that is an order of tribunal which empowers the tribunal, the railway, to go for a revaluation. So on three grounds they are taken. Another my only submission on
anyway you accept notice. Are you on KVA?
That is this is
KVA. Have you filed KVA?
I have already entered appearance 17, but my name is not appearing in the
not appearing.
Tribunal is expressed in paragraph 14, 15, 16. Elaborately it was expressed.
Let us requires consideration.
Yes.
And the latest law is on 9th February 2026,
of which OPSC?
Yes,
BSc.
Jharkhand Public Service Commission versus State of Jharkhand, full bench decision.
What? No. Whether this decision of the appellate court is considered by that?
In another case, considered 5 and 8 is also equivalence. Para 5 and 8.
Take.
Need to break up factual.
These are all fact specific.
कॉपी एक्स्ट्रा दे दे इधर दे दे এটা হচ্ছে শুভম কার
That is not that.
Here, Malas, the railway authorities have accepted.
Another decision is there also.
This was a judicial appointment where they said since the High Court appoints, High Court means full court, all judges will be expired, and therefore there are different considerations. It's matter requires examination.
And moreover, my lord, in this case, we are in the first panel. We became out of panel without a notice, my lord. And since last 2 years, in spite of complete training, we are out of job, my lord.
Panel consists for the petitioner, petitioners. First one. It is a prima facie case made out for issuance of emergent notice and grant of reprieve as well. First one. Issue notice. Mr. Paddy, the DSG, accepts notice for 2 services. 2 one also.
One is the private office.
127. 227.
One Mr. Rautraj.
Rautraj, the net counsel, appears for
227. Yeah.
OP number 1, which is a private party. First one. Matter lies in a narrow compass and therefore post it in the 3rd week of May 2026. First one. Okay. Any precipitory action?
Well, they've already indicated.
Application 9 number. So is moved, supported by an affidavit seeking stay of the influence order of the trial. First one. Since any contempt is moved?
No, my lord.
Nothing.
But they will demote me right now. Well, it's already on Friday. They have issued notices in compliance of the judgment. Let them not take any coercive action during pendency.
Since matter would be examined in detail on the next date of hearing, there shall be no precipitatory action under the impugned order of the trial till next date of hearing.
May
If not taken,
if the matter is being examined.
If it was already been taken, then it is.
No, then you have to restore. See that Chamundi puppets, you have to restore. Yes.
May also fix a date, my lord, because
last week, third week it will come. We can't fix day.
Because since last 2 years, in spite of complete training, we are out of promotion, my lord.
Promotion, no?
Yes, my lord.
All are in service.
On 18. 19 May.
Obligement.
Okay.
This item 8 is also identical.
Same.
Yes, ma'am. Common judge.
Same. Yes.
Item 9, WBC 10624 of 2026.
Petitioner is a loaning, my lord. He has taken a loan for tractor, my lord, agriculture purpose, 5 lakhs 50,000. 5,000 on 31/3/2014, my lord. The loan was became NPA on 36/2000.
This is agricultural loan.
Yes, agriculture tractor loan. Rental.
It's stated as agricultural loan.
Yes, sir. 36/2015 is the date of NPA, man. 36/2015, man.
30th of June 2015.
15, man.
How many installments you had paid by then? How many installments?
That is not with the petitioner. The petitioner father is looking after all these things. He died in 2018. And after 18, all the action has been taken by the opposite party bank. After death of the father, all the action has been taken and put the property which has been mortgaged. They took the tractor, my lord, they took the tractor, possessed the tractor on 16/3/2017, my lord.
This tractor was of pledge.
Hypothetical.
Hypothetical. Because possession
has been taken on 16/3/2017. And thereafter.
1 second. Position on
16/3/2017 by the annexure 1.
Yes.
My lord, the father died on 12/10/2018. Niranjan Mahali, my lord. After death of the father, they have taken all action because the mortgage of the property in the name of the father has been given during time of taking the loan, man, except the hypothecation also.
The hypothecation of vehicle, mortgage of
property, my lord, of which stands in the name of the father, man.
Is it ancestral property?
Yes, my lord, ancestral property.
Where is the material to show that it's ancestral property? Where have you pleaded?
My lord.
And where is the minimum material?
In
characteristic.
My lord, paragraph 5, I have stated that my father died. Thereafter,
No, it's the ancestral property.
Paragraph 6, I have only stated, my lord. But all the actions are taken for sale of mortgage property after death of the father without giving notice to all the legal heirs, my lord.
Legal heirs,
legal heirs, I have stated.
There is a presumption amongst Hindus that every Hindu family is a joint Hindu family. There is no presumption that every Hindu family possesses the property.
Yes, ma'am. That I have not stated.
You can't state also.
You
What amount you will pay now?
As your lordship direct, because
No, I will not tell.
it has
Because you have to show bona fide for us to pay.
I have taken instruction, he will pay within 15 days, 3 lakhs to 4 lakhs. It is 16 lakhs, somewhat the property has been sold. My lord,
It is sold now.
yes, my lord, sold, but possession has not been given. I am in possession.
That makes no sense. When it was sold?
My lord, it was sold in the year
27th July 2023.
Yes, my lord, that's it.
You go before the DRT. That is
My lord, if your lordship will issue notice to the auction purchaser, if
Why?
you are ready to take it with interest, then I can save my property.
Tell the same thing to them.
Well,
You
I
can't convert the, see, if it is a housing loan, we can understand.
Yes, ma'am, I don't.
You are not telling how much money was repaid by the borrower.
That is not, they have not supplied to me.
So did you go to bank? They will not come in such a.
No, I have gone, my lord, but
You
they have
should have, where shows, where have you given the letter to the bank?
no
Saying
letter
that
has been.
how much money my father
Well,
has
no
paid,
letter
how much
has
is
been-
due. We
no
want to
le-
pay.
No letter has been given, ma'am.
Then nothing.
No letter has been given.
Not even a case for DRT because already the limitation is passed.
No, my lord, in the notice is there, 10/3/2026, they have given the notice to vacate the.
You go to DRT. Take note. Challenge is to the coercive proceedings of loan recovery constituted under the provisions of the 2000 Surface Act 2002. First one. It is in respect of a tractor loan, which is said to be agricultural in nature, in a sum of rupees 5,50,000, borrowed on 31/3/2014 by the father of petitioners.
No, the petitioner, it is in the name of the petitioner.
By the petitioner.
But father has
But how
taken it.
father will
Yeah, I have-
will die, but how liability will go?
Well, the father has done it in my name at that point of time. And it died and thereafter.
First. The account was certified as NPA with effect from 30 June 2015, comma, the installmental payments having not been made. First one. Possession of the hypothecated vehicle was taken on 16/3/2017. First one. Father of the petitioner died on 10/3/2018.
12/10.
12/10. Yes. 12/10. You said 12/10/2018. 2018. First one. We are told at the bar that the other security property has already been auctioned on 27th July 2023. First one. Counsel for the petitioner draws our attention to the possession notice dated
10/3/2026.
10/3/2026. First one. Next paragraph. Panel counsel for the petitioner bank submits that the petitioner can have the redressal to his grievance at the hands of the DRT as provided under section 17 of the 2002 Act. First, no extraordinary circumstances have been shown to us, comma. We agree with this submission. First, next part, in the above circumstances, petition is disposed of, preserving liberty to the petitioner. How many petitioners? One petitioner to approach the alternative forum for the redressal of the grievance. In that connection, all contentions of the parties are kept open. Next.
Item 10, WBC 10-10-10179 of 2026.
May please, Your Lordship. Petitioner is a poor fisherman. And where is the opposite party number 3 is the loaning. And the opposite number 4 is the servant. She is the wife of the 3. My lord, he has taking the advantage, he has applied for the Indra Awas. Taking that advantage, he has taken some signature in the blank paper, also taken this.
How we can decide all that here?
And I am going to that, find out. My lord, in this case, he is a co-guarantor. He has no knowledge about the loan. Where they came
no,
from.
how we can decide all that?
I'm going to that, find out. Well, he came to know, my lord. Kindly see Annexure 3.
Now there is a police case investigation going
Yes, yes, sir.
But what we should
No, your lord, see, he has got the report, my lord, in Annexure 3 from the police that your house is going to attach. Thereafter, he has inquired the matter. He has filed an application before this Honorable Court. Right, CLMP number 20 of 26. This Honorable direct to inquire the matter. And also, after the direction, my lord, the police has registered a case at Annexure 4. And the FIR was registered against the Looney and his wife as 420 and 34 IPC. Recently, my lord, he has no knowledge because he accepts ODS measure.
should decide.
Because my lord, since when I came to know, my lord, I have immediately filed an order 9 to 13 for set aside of the expiry order. That application is pending. Since
before?
Pending the DRT. And also I filed the stay petition because the recovery position already started.
You process that.
My lord, you will also kindly say, but since the police has found that it's primary case on 420.
No.
Because he's a poor.
No, we can't give you all that. That relief has gone now. That's for motor vehicles set.
But because he is a poor, but he is uneducated.
Maybe.
That he has no knowledge about that loan.
Everything is a matter of fact. Actual disputes, we can decide this.
Because
any other alternative suggest to it, direct. Your matter is pending before the DRT.
Yes, sir, but till this no course of action.
No, we can't. We are not DRT. We'll tell the DRT to take action on your interim application. Have you filed interim application?
Yes.
Yeah, in DRT, what is it that you are challenging?
That is the expiry order. I will challenge the expiry order.
Order of?
DRT, my lord. That order dated?
DRT passed expiry order against you.
Yes.
Saying?
Certificate.
I have filed a MA number 30 of 2026 for set aside of the expiry order.
You were not served in the matter? Were you not served?
No.
Huh?
No. I have got the information from the police.
When did you get the information from?
That is Annexure 3.
When it is?
That is 23/12/25.
23/12/25.
My property schedule B, the 5 days will.
1 second. 23/12/2025, what they said?
The police has said that the police that has got the information from the police. The police has sent smooth execution attachment order of property in recovery proceeding.
Police assistance in smooth execution of attachment.
He has got the information from the police.
Attachment order. For attachment order.
Yes.
The police has
That attachment order, that is page 25. That no ODR.
No, if for taking possession, we can understand. For attachment property, what is that? Police assistance.
That applied for attachment
No,
of
that
the.
is an application to the superintendent of police, not the police.
This must be under DRT Act.
Yes.
DRT Act, self certificate.
Except this house, there is no. But
Correct. Everybody will say that only. Everybody will say, except this house, I have nothing. But why did you mortgage it?
Because only his business only fishing.
Nothing.
Nothing.
We're not it. We'll direct the DRT to take up your application on a war footing. Otherwise, you have to dismiss it. If you agree with the proposal, we will only say that. Otherwise, on merits, we are dismissing the petition because disputed facts are involved. We cannot examine all that. Which proposal you may give?
But police is now inquiring that matter.
They will inquire.
Till disposal of the police
No,
investigation.
they will take another 5 years. It's a public.
Time limits. Some time limits.
That we'll tell the DRT to take up your Order 13 Rule 9 application.
Yes.
Order 9.
Petition prayer. Order 9 Rule 13. Petition prayer reads as a first one. Next one. Learned counsel appearing for the petitioner having argued the matter very fairly agrees with our submission, with our suggestion that
He's one petitioner. Yes. But he's the co-guarantor.
His application filed under order 9/2/30 seeking of the DRT order dated 24/6/2025.
Which is expert dependent.
If directed to be considered on a war footing, justice would be meted out to his client. First off. Next paragraph. In view of the above, the petition is disposed of, requesting the DRT to take up petitioner's subject application for consideration on a war footing. First, in that connection, all contentions of the parties are kept open. First, it is also open to the petitioner to seek reprieve at the hands of the DRT if there is, if grounds do exist therefore. First of all. Yes, no pause. Next.
That is, my lord, that application of MA is 30 of 20.
MA 30 of
26.
2026.
My lord, my request, my lord, till then, my lord, annexer say that the recovery proceeding already started.
Yeah,
till then,
you take you move memo there. Yes, next.
Only that that line you are.
No, we have said liberty. We have reserved liberty for that also.
Sympathetically, also.
Sympathetically. But in accordance with law. Sympathetically, but in accordance with law.
Only sympathetically.
Yes.
Item 11, 10812 of 2026.
Yes, sir.
Sir, challenge the election of the dear in disposing of my interim application in the second. Yes, sir, my lord. Yes, sir. The petitioner earlier removed this application before this honorable court, my lord.
But disposal of essay.
109 of 2023.
My lord. That also interim application are pending regarding stay of the position, my lord. There are
IA number 1705 of 2025.
My lord.
And 284 of 2026.
My lord.
These are yes to be disposed of.
Disposed of, my lord. Earlier, this petitioner has moved this honorable court, my lord. And this honorable directed the petitioner to move necessary application for stay.
No, you have moved.
That I also filed within a week, my lord, as per direction. But till there, they are not disposing or not taking up this matter, Lord.
You are borrower.
I am the borrower, Lord.
Petitioner who admittedly is a loanee. He is knocking at the doors of writ court with the following prayer. Quote that, please. Next one. Learned counsel for the petitioner argues that his client's two applications, that is, IA number 1705 of 2025 and IA number 284 of 2026 filed in
Essay 109 of
Essay 109 of 2023 are not being taken up for immediate consideration despite urgement of urgency grounds. And therefore, this court should be. First point. He also tells us that right to speedy remedy is one of the facets of Article 21 of Constitution of. First off, he highlights the adverse consequences if the subject applications are kept pending long. First off. Next paragraph. Regard being held to the innocuous nature of the prayer and also that the other side would have opportunity of opposing the subject applications before the DRT, notice to OPs is dispensed. First one. Next paragraph. Agreeing with the submission of learned counsel for the petitioner, we dispose of this petition requesting the DRT Cuttack to take up subject applications of the petitioners on a war footing so that no prejudice would be caused to him in view of section 14 order dated 12/9/2025, my lord. 12/9/2025, passed by the collector and the district magistrate Mayur. First one. In that connection, all contentions are kept over. Registry to send a copy of this order to the OPs by speed post, who may seek recall of this order if grounds do exist therefore, since this order has been made ex parte.
May I plead my no persuasion till that?
No.
I am ready to deposit some amount.
You do that before the year.
Lordship, may I observe that, your Lordship?
It is this order will not come in the way of petitioner seeking any reprieve at the hands of the DRT by offering a reasonable sum of money to the appropriation of loan account.
Item 12, WBC 10909 of 2026.
My lord, petitioner is a loany my lord who has taken the housing loan my lord of rupees 30 lakh my lord.
Of 30 lakh?
30 lakh.
On?
It has been disbursed on 22/24 my lord, but the interest has been charged from the year of September 23.
The loan was taken when?
The loan was disbursed on 22/24 my lord.
22/24 means?
22/2/2024.
Oh, 20th of February.
20th of February
2024.
My lord.
Oh.
But the statement shows, my lord, statement shows the housing loan. The statement shows, my lord, on 30th September 23, it is disbursed and interest has been charged for 4 months. But it has not been disbursed, my lord. Prior to
it was not disbursed.
No. They have kept the amount and
it was
sanctioned and interest charged.
Interest is chargeable when the amount is released.
Only after disbursement, interest has to be charged. But they have it is a page 21, my lord. Kindly peruse that page, my lord.
Now what happened?
Now, my lord, there is a due of 5,63,855 in page 20, my lord. That is on 16th March 26. Without issuing any notice under 13.2, they have straightway went to the 13.4 and they approached the district collector for possession of the property, my lord. I have not received any notice.
No, possession notice has come now.
Only the notice from the collector I have received, my
notice has been issued to you.
Yes, my lord. They have, and in that court also I have appeared and also stated that I have not received any notice. I have already approached the bank.
How much money is due now, as of now?
16th March, the amount due is 5,63,855, page 20, my lord.
By way of installments?
By way of installment. And the EMI is till 2038.
38.
My lord. So I am ready to pay some amount. And
that amount, whatever is due, that amount you
87,000 has to be adjusted as they have interest charge earlier.
Let us see. That amount is 5 lakh?
5,63,855.
You pay that amount.
My lord, only I can pay now 1 lakh rupees now. And the rest amount, I have filed a petition before them that the rest amount may be adjusted and replacement during my 2038, my lord. The EMI is there. I am ready to pay that adjusted with interest. I will pay my.
That means to regularize
the account. The
restructuring of the loan.
Yes, replace the amount.
No, we cannot do that.
Otherwise, your lordship may direct that I will within 6 months I will pay that amount and some amount of 1 lakh rupees I will pay now, my lord.
No. What is that loan amount? What is the
5,63,000.
You pay that amount. For that, we'll give you 4 weeks.
5,63,000. I have a small shopkeeper. I have suffered.
30 lakhs you have taken.
Only for only to construct a house, only residential house. So the house has been constructed, and thereafter I have suffered illness, and I could not able to attend my shop. For which I could not able to pay.
What are you?
A small shopkeeper, my lord, in the
shopkeeper.
Yes, what is grocery shop in the village, my lord. I am ready to pay now 1 lakh rupees, and that 86,000 has to be adjusted, which comes to around 50%, my lord. And the rest 50% I will pay in 6 months.
But what is the amount which should be paid? That amount if it does not pay, how to pay? It's all public money.
I am ready to pay with interest, my lord. That delay period, I am ready to pay that interest after 6 months, my lord.
No, question is not that. Question is, it's a public money. We cannot be merciful to the borrowers because that will be cruelty to the public. To pay 30% of that.
Yes, sir.
You pay 1.75 now.
My lord.
Okay. Issue heard that counsel for the petitioner borrower. First off. Issue emergent notice to the OPs. First, till next date of hearing, no coercive action shall be taken by the OPs in respect of security property concerning the loan account, subject to petitioner paying to the said account a sum of rupees 1.80 in pre-equalized weekly installments. That is 60,000, failing which not only the reprieve stands rescinded, but the petition itself runs the risk of dismissal on that ground. Per se. So 1 week 60,000, another week 60, at another 60. All right.
All right.
Small matter.
This is matter relating to transfer.
Can we come back within few minutes? Yes.
This is the matter. I am challenging the order of the administrative tribunal because it is a matter relating to transfer. It is a transfer matter. In transfer matter, I am working as income tax officer at
ITO.
ITO. I am supposed to transfer.
1 second. ITO at Bhubaneswar.
3-1 Bhubaneswar.
Since how long?
Since 5 years I am here. In Bhubaneswar.
Which year to which year?
That is in 2020 to 2025.
2022
till now.
Till now. 22 till now. 2020.
2025.
Till now.
26.
Madam.
Still continue.
Still continue.
Still continue. Prior to this order of transfer, I have already given option to retain, not to retain here, but place in some other places, in 3 places. One from Bhadrak, another from
before you came to Cuttack.
Before the transfer order. So without considering my option, I am not agree to stay at Bhubaneswar because I have already stayed at Bhubaneswar. But that 3 places they have not.
What is the retention period?
Retention period is 5 years.
5 years. Maximum 5 years.
Maximum 5.
So now you have to go.
I am ready to go. But I have a giving option due to open heart surgery of my wife. So let me retain in 3 places. One at Paradip, another at Bhadrak, another at Jashpur. But they have not considered so and make him transfer to Berhampur. That's why I approached the tribunal. The tribunal is
the 3 places you want?
Bhadrak, Jashpur Road,
Jashpur Road.
Jashpur.
Bhadrak, then Jashpur Road.
Or Paradip.
Road.
Paradip.
And Paradip.
The
they have transferred you to what?
They have
transferred to Baleshwar.
Baleshwar.
How many kilometers away from these 3 places?
Bhadrak is only.
From Bhubaneswar to Baleshwar, 100 kilometers.
No,
the 30 kilometers.
Baleshwar and Bhadrak is differences?
55.
I am at Bhubaneswar. I want to. I am at Bhubaneswar. From Bhubaneswar to Baleshwar, it will be minimum 70 to 80 kilometers.
No. From here, the Baleshwar is 170 kilometers. Here to Bhadrak is 100 and 65 kilometers from Bhadrak to 60 kilometers from Bhadrak to Baleshwar.
Any one of these 3 places you consider because wife has undergone.
That I am only requesting. They have not considered.
My lordship, I am not running this record. The professors from SC Medical every day they are going to Baleshwar.
Is it?
Yes.
Baleshwar.
It's a 2 hours journey from train from Baleshwar to Cuttack to Baleshwar.
No,
the officer in central government level, they are not good to Baleshwar. It's a very convenient place.
Baleshwar.
Yes.
What the tribunal say?
Tribunal admitting the case, it is a prima facie case to be considered by the tribunal. But the tribunal, without granting interim protection to me, has passed the order. So in that connection, this honorable court has a decision in case of transfer matter. If a case has been adjudicated, the interim protection should be given to that petitioner. But the tribunal has failed to do so. That's why I come before this honorable court and order of this honorable court I am placed. Division bench order.
When
in case of transfer,
when it was passed?
In 2002.
Does it refer to Varadhara versus State of Karnataka?
No, sir. It is Odisha High Court decision.
No, makes no sense. Varadhara apex court say no interim order in transfer matters. First duty of the employee is to report their transferred place. Then make a representation to the government. Then government will consider. That is how apex court justice, I think, yes, Venkatramaya.
Also giving representation. That is not there. I have also giving representation.
Have you reported for duty?
They have already
for duty. Then the question arises.
They have already relieved me from this place, and I am in transit.
You go there and report for duty first. Where is the transit?
So for one place to another, that is 10
judgment we can consider because not even one single judgment of the apex court it has considered.
This is decision of the Odisha High Court, my lord.
That's all right. It's a fact specific statement, therefore no law emerges from that.
Once in transfer order, if the court has accepted the OA, admitted the OA, so he has to giving the protection. So what is the necessity
That's
to
not the law.
accept it?
That is not the law. The law is
That person
you
is
report for duty, then make a representation for consideration. Take out that the Varadharao versus State of Karnataka.
I am also giving representation.
That question arises after you report for duty. By giving representation, you cannot squat in the same place.
They have already stated in the transfer order, you join and then you represent.
Correct. That is the correct position of law.
That they have mentioned in their own constitution. So once I have already.
They have said Varadharao only. They have not mentioned Varadharao, but they have, that is the law.
But any three places may be considered. I have no objection. I have no fascination for
volleyball, not Varadhar.
My lord, I have no fascination for
observation. Let me see last line.
Yeah.
14 days time is allowed to the respondent to file reply, put up on 22nd. That means tomorrow it will come.
That is there. We are not on say anything about this. We say that once transfer order is
employee who has suffered a transfer order is knocking at the doors of Brit Court for assailing the denial of interim protection by the Cuttack Central Administrative Tribunal Cuttack in OA number.
What is OA number?
169 of
169 by 2026.
2026. First time. Next one. Learned counsel for the petitioner vehemently argues that once notice has been issued on the OA, ordinarily the interim protection has to be granted against the transfer order, especially when his client's spouse has undergone open heart surgery. First time. Learned DSG Mr. Paddy made submission in justification of the impugned order of the tribunal with denied protection, interim protection, saying that main matter itself is posted tomorrow and tomorrow, semicolon. Even otherwise, petitioner joining duty at the transferred place is a sine qua non for consideration of the representation if he has any grievance against the said transfer. First of all, in that connection, he presses into service Apex Court decision in B. Varadharao versus State of Karnataka, AR 1986 SC 1955. First, we broadly agree with the submission of learned DSG. First, in the above circumstances, this petition is disposed of, requesting the tribunal to take up the subject OA for consideration, or at least the application for a temporary protection at the earliest. First, in that connection, all contentions are kept open.
I have already opted for three places. If any place can be considered, I have no case.
No. Next.
Item 14, WBC 16228 of 2024.
Yeah.
The lawsuit is CA lawsuit's last order dated 24th February 26 May.
24 February 26, yes.
There is a case, my lord, I have repaid all the dues, cleared the dues, no objection certificate issued August, my lord. Till now, they have not cleared the Cibil, and now, after the order passed on 24th, on the same day.
Where is that order?
24th of February 2026.
26 order.
No, 24. In the IA, this order was passed.
For a modification of the order?
Yes.
What is that modification you want?
My lord, your lordship has directed them to clear the Cibil score. On that day, till now they have not cleared the Cibil score. Otherwise, on the other hand, on the 24th, my lord, they have again intimated another portal that is National E-Governance.
Yes, brother, what is it?
No, my lord.
Not there.
Till now they have not.
Share a copy with them.
I'm sharing. Lord, the sequence of dates is like, on 24th February, lordship passed the order. Lord. 26th February, the OA before the DRT was withdrawn. Lord. On 3rd of March, if your lordship may kindly come to page 3 of...
One second.
The chain mail.
OA was, brother, OA was withdrawn on which day?
26th February.
OA number? $487 of 24.
OA number 487 of 2024.
This bank had filed.
Bank had filed.
You have withdrawn it.
We have withdrawn.
On
26th February. Then, my lord, the chain mail copy which I have handed over, page 3, if your lordship may kindly see. Page 3, on 3rd of March, from ICSA to transunion.com. The Cibil is TransUnion Cibil, my lord. 3rd of March, he communicated, the content is page 4. Please find disputed account number so-and-so, kindly de-link the account number from the complainant record and confirm on priority. Page 4, if your lordship may see, the content is there. Mail is 3rd of March at 9:45 a.m. Then, my lord, the Cibil asked some further queries on 7th of March, my lord. About that, page number 2, March. So we informed to Cibil on 3rd of March, my lord, in compliance with lordship's order. And finally, on 10th of March, the first page 1, the response, it was, it is delinked.
It's already delinked now.
10th March delinked, he was informed through mail also that it has already been done. What he is, your lordship may see, please note that the disputed account number such as cannot be removed. No, it's a report. Your lordship may see, yesterday only I have downloaded. It is still showing, my lord. This will show. How can it will? Let me explain just how it works. But the purpose of the CIC, which was the Credit Information Companies Regulation Act, it was established under the RBI. The purpose is that all the payment records of all these customers are saved on that. Report is only updated. This date, the NPA, this date default happened, this he closed or settled. Closed is fully amount paid is closed. Settled is there is a discount also given by the bank, haircut, then settled. So the report remains in the Cibil for all the time for all banks and financial institutions.
As a matter of record.
So that the future, tomorrow's, before granting any new loan,
that will be a factor.
They will continue the underwriter, they will underwrite the risk based on the payment track record and what happened, whether there was initial default or thereafter default, all records remain. Records never get erased, my lord. Not for any other bank and financial institutions. But it is updated.
They are government records, but they are updated.
Updated in sense
based upon inputs.
The banks, this account is closed now as a settled account, not the closed. Because he has settled, we have given the discount also. So it will come as settled. So that is there in the Cibil report. It is not correct, man.
Now order is not complied with.
No.
Yes. If order is not complied, you should go for contempt.
Your lordship has given me liberty to move, your lordship, my lord.
Correct.
My lord.
Move for what?
It is not the explanation, my lord. I am explaining, my lord.
Sorry. Now why we should interfere in this? If the order is not complied with, if our mandate is not complied with, the appropriate course is to file the contempt.
I can file contempt, or it is, I am bringing it to Lordship's notice because the explanation given by the same letter, your Lordship must see the.
No ground is made out for modification.
Please, my Lord, have a glance to the letter submitted by them.
In as much as
the Lordship will not listen, my Lord, kindly glance, have a glance to the letter.
Assuming that what
Sir, I would do that, my Lord. But what he has summarized is totally false.
Correct, but that is not a ground for modification of the order.
I'm modification and clarification, my Lord, because your Lordship has given me liberty to bring it to your Lordship's notice. By maybe my nomenclature may be wrong, but I have brought it to the notice of this Honorable Court, and your Lordship must see the explanation they are giving. He has given a long lecture, my Lord. Your Lordship may kindly have a glance at the letter, man.
You file your affidavit.
My Lord, kindly see the letter.
Let him file the affidavit.
Sir, he misread the email. Misread the email. The email says, please note that, sir, I am reading that first page. Greetings from the TransUnion Cibil. We write to you the reference to the inquiry number such and such. Please note that the disputed account number such and such cannot be removed as the same has been reported with complaint PAN number by your credit institution. They have again reported, my Lord. That is what I am trying to bring it to your Lordship. Your Lordship may kindly see my Lord, my miscase, my Lord. My miscase at page your Lordship may see. The entire submission made is totally, my Lord, misleading, your Lordship. Your Lordship may see my page 11 of my miscase.
Which you file your
I'll file the
affidavit. Well, how you have complied with our order, and how that the order has brought about justice to you. Well, people come here not to get just order. There should be meaningful implementation of the order. As long as this remains, you will have some suffering, some advantage. Whatever you want to say, see, now you have given this. We can't understand what is this. It says everything here. Mongoose, cobra, everything is put here. You file your affidavit as to how you have complied with our order. He will be happy.
The only one submission, Mr. Miller, for everyone as per the RBI's guidelines, the reporting happens monthly basis.
Anyway, you give that.
File the details.
Learned panel counsel appearing for the is granted a period of 10 days for filing the affidavit as to how our order dated 24/2/2026, whereby the subject petition was disposed of with a direction, has been meaningfully implemented. First, non-filing of affidavit may result into punitive action against the bank officials. In the meanwhile, if any deficiency is to be addressed by the bank, the bank may do it. Okay.
Item 15, WBC 10090/2026.
15, may I please, madam?
Yes.
Wrongly correct.
Correction.
Wrong. This office is wrongly correct.
What is
my lord?
It's missing. It's missing.
Petitioner name
rectified.
Tonubala Mollik alias Tonu Mollik is wrongly reflected in order sheet dated 8/4/2026. Tonubala Mollik and Tonu Mollik.
This is on your application. It is moved.
My lord, application is correct.
Our code, the
so much registry.
Registry has moved this matter post disposal, seeking to have leave at the hands of court for rectifying petitioner's name in the cost title. First, leave accorded and accordingly rectification to be effected. First one, a free rectified copy shall be furnished to the litigants if applied for.
I have already applied and the certified. Can it be corrected by the press?
No, you want the correction to be in the certified copy.
But it's certified copy. I have already applied. Court master can go.
It must have been taken. No?
That makes
It is in the
not
website.
necessary.
No.
You take that now. It's from the website you have taken.
No.
Certificate copy. They will issue a certificate, rectified certificate copy. We need not take it back.
No, court master can be corrected.
No, it's not like, because in the website.
You want that one? Darkness.
No.
On the website, it will be.
Many things
to apply for them. Yeah, right. We have copy to be acted upon.
Already case is pending, your lordship. Case is.
You have been asked to deposit certain amount. No.
Item 16, Writ Appeal 790/2024.
You will not cover by lordship.
Item 16, I am for the appellant. Your lordship, it's a matter relating to sanction of pension of.
Is it covered by the judgment?
Covered.
Good.
By your lordship.
Have you rectified all these factors? Changed the factors?
It was covered by the judgment passed by your lordships in case of.
Mr. Chandra Malik.
Mr. Chandra Malik. 17 also same.
It is 16 and 17.
Matter. Eighteen, my lord, it is also, it will be covered, my lord, because he was regularized as Group D Khalasi after 2 years.
Covered by lordship order, my lord.
It's another order.
18.
Item 18, my lord.
16 and
Item
17.
My lord.
This one.
Right.
18, 16, 17, this one. 18.
Corresponding changes you have to do.
My lord. For the purpose of minimum pension.
Other things, only this undergoes change. See.
My lord, in item 18, for the purpose of minimum pension, my lord, the period of just it shall be counted, not the entire period.
18 is covered by which judgment it is?
Narsuprada.
No, State of Orissa versus Juna Parida.
Juna Parida, my lord, that is, it will be some period will be counted only for the purpose of minimum pension, not the end.
But that is not the order.
Yes, my lord, lordship.
That is the order.
That is the order.
No, that's the The subject matter.
My lord.
This
one line.
I have already given the order.
Yes, sir, that is what.
One line I will speak, my lord. That your lordship may not dismiss the appeal, dispose of the appeal.
Yeah, same.
And this case also your lordship disposed of. Appeal are disposed of in terms of the order passed in Naruspada and Vasan Das. My lord's order, my lord.
Let Narsu Pradhan and Vasanti Das.
Vasan Das. My lord's order.
This intra-court appeal by the state seeks to lay a challenge to a learned single judge's order dated 5/9/2023, whereby the respondent employees WPC number 28909 of 2023 having been favored, relief has been accorded in terms of para 6 thereof as under. Next paragraph. learned counsel appearing for the respondent submits, and we agree that the subject matter of this appeal is substantially similar to the one in Vasanti Das, one in writ appeal number 1598 of 2024 between State of Odisha and others versus Vasanti Das, disposed of by us on 2/2/2026. Wherein paragraphs 12, 13, 14, and 15 read as an. These paragraphs
something has been decided. Judgment of
Next, correct. In the above circumstances, there is nothing more to be adjudicated in the matter. And accordingly, in terms of Vasanti Das, this appeal is also disposed of. Within what period you will dispose of? First of all, the benefits shall be extended to the respondent employee within an outer limit of 8 weeks. We have said 8 weeks in all cases. 8 weeks. Failing which delay may entail levy of ₹500 per day, which may be, after payment to the respondent, recovered from the erring officials of the department.
Item 19, Writ Appeal 1748 of 2024.
My lord. In this writ appeal, my lord, writ appeal was preferred challenging the order dated 24/3/2023, wherein the respondent has approached your lordships for grant of family pension, disability family pension, that is on mental retardation, was 90%. 90% mental retardation. Certificate was issued from the issue involved is, my lord, the father during his lifetime has not informed the department about retardation of his son, mental retardation of his son. After the death, the son and the legal heirs of the files for pension, seeking for pension on the ground of mental retardation.
Yes.
That is the only ground now.
Whether law requires that the employee should inform that he has got a mental retard person.
There is a pension rule.
Pension rule says if there is a dependent mental retard, he is entitled to pension.
56.
That is how judgment has been structured. Though many paragraphs are dedicated is another thing.
My lord.
Which rules?
56.
Read.
56 of the pension rule.
1992 rules.
92 rules. There 56E, 5E. In the case of widowed, divorced, disabled widows, disabled, divorced daughters, even after attaining the age of 25 years, till their remarriage or death, whichever is earlier, subject to condition that in case of divorced daughter and disabled divorced daughter, the family pension for life from the date of death of her husband, and there is no other eligible unmarried daughter beyond the age of 25 years, and the disabled son, disabled unmarried daughter to receive the family pension. The benefit of the family pension for life shall be admissible to the widowed divorced daughter only after the cessation of the claim of disabled widowed, disabled divorced daughter. The other conditions governing the grant of family pension to the unmarried daughters as specified in clause D shall also be applicable to the widowed and disabled divorced daughters for grant of family pension in their favor. So here, my lord, all the
provides for simply.
It provides only for daughters. My lord.
It provides for grant of disability pension.
Disability pension.
Even to a son.
Even to a son, it is there next, my lord.
Correct. I read that. Now this is a widow or
son, my lord.
Son.
He is a son.
Next, it comes to the next provision.
Next provision, my lord.
Provided that.
Provided that thereafter, if the unmarried daughter, including widowed, divorced daughter of a government servant is suffering from any disorder or disabled of mind or is physically crippled or disabled so as to render him or her
unable to
earn a living even after attaining the age of 25 years, the family pension shall be paid to such son or unmarried daughter for life subject to the following conditions.
Correct. What is wrong with the order? There is 90% disability.
Mental retardation.
Yes, we should look after the mental retards. Even those who are capable of fully mentally capable, they are not in a position to look after themselves. The disability, mental disability.
Malnutrition.
Right. This intra-court appeal by the state and its officials, be seated, state and by its officials, seeks to lay a challenge to a learned single judge's order dated 24/3/2023, whereby WPC number 7854 of 2023, having been favored, a direction has been issued for the grant of family pension on the ground that he happens to be a mentally disabled son of the deceased employee, disability being 90%. First one. Next paragraph. Learned counsel appearing for the respondent opposes the appeal, contending that even in terms of Rule 55 it is, 56. Rule 56 of Orissa Pension Rules 1992,
Subrule 5E.
56, Subrule 5E. Of 1992 rules, family pension is payable to a disabled dependent son of a deceased employee even after he attaining age of 25 years. First one. Next paragraph. Having heard the net counsel for the parties and having perused the appeal papers, we decline indulgence in the matter, broadly agreeing with the submission of the net counsel appearing for the respondent employee. First one. Rule 54, sub-rule 5, 56, sub-rule 5, clause E, proviso, reads as under. Only proviso. Okay. This and this. All right, I have put it here. Let's see and print it. Next one. Despite vehement submission, learned AGA is not in a position to point out what legal lacuna the impugned order of the learned single judge is pregnant with. First one. When a policy of the state is promulgated in the form of rules for protecting the dependent children of the deceased, the claim for family pension on demonstrable disablement cannot be denied by a welfare state as ordained by the Constitution. First one. This reasoning has animated the impugned order. First, next one. In the above circumstances, this appeal fails. First, the order of the learned single judge shall be implemented within a period of learned single judge said 4 weeks.
4 weeks.
6 weeks. Within a period of 6 weeks, reckoned from this day. Without driving the
there is delay of 400
to take up delay of contempt proceedings.
See, IATA disposal.
One more round above.
We have filed IATA.
The above part, 650 days. The appeal has been preferred after brooking a long delay of 650 days. First one. An application in IA number
428.
428.
No.
28 days.
428 days. IA is 4604 of 2024.
Is moved, supported by an affidavit seeking condonation of delay. First one. Delay is too long and the explanation offered is not plausible. First one. A perusal of the application and the affidavit would show that the matter has been approached with militant casualness, and therefore no indulgence can be shown by the court. First, this is another ground. Okay.
In all other in all other cases, my lord, delay is also there.
These cases,
my lord, that paragraph may be added in
Previous cases.
previous cases.
In one to six,
From 16, 17 and 18.
16, 17, 18.
Same paragraph, we can add that. Number of delays.
642, 250.
Item number 19, my present.
19 show name of panel counsel for the courts. AG office.
Item 20.
Item
Rate appeal 2817 of 2024.
Item 2021 matter relating to Sarat Chandra Parida, that Chotra's case, the appeal is pending. 197, yes.
We have taken to
My lord.
197.
197.
But the delay is 650 days, etc.
Because those cases will be decided at a batch, in the batch cases is pending before us.
For 650 days delay, you pay 25 rupees per day, we will then issue notice. That is the rule we have made in our rest of the matters, no?
Let it be tagged with that.
No, for tagging also you have to make the payment. No free tagging at all. 650 days. This intra-court appeal is preferred after booking a long delay of 650 days. First, an application in IA number 7366 of 2024, supported by affidavit, is moved seeking its condonation. First, in matters like this, courts have approached an yardstick of showing bona fide prima facie, so that notice can be issued on the application, and after hearing the other side, the same can be disposed of. First, per day, rupees 25 has to be paid.
20 was there earlier. 20 was there earlier.
20. 25 you have made, 25 also reaching subsequently. But first up, the issue notice, if the appellants pay a sum of rupees 650 into 20, it will be 13,000. 13,000. A sum of rupees 13,000 in the registry within 4 weeks, failing which the application would stand rejected in limine, and as a consequence, appeal also. Okay. Next.
The 20, 21, 22 all.
You see, 395 days. Delay is 395 days.
In the next 396.
See, 395 days, how much it will be? Just work out in the same order.
22.
22.
In 21,
it is 395.
395 days.
In 22.
In 22, 396. In 23, 395 days.
And 26 also same.
26 also. 801 days. 801 days.
26 is not.
No, my lords.
Only delay is there, but it is against OA.
Let them deposit that money so that citizen will get some money. 24.
Item 24.
It is GPA.
Item 24, WH 279 of 2024.
Delay of 801 days.
24, 25. Your lordship has already was pleased to decide the matters.
24, 25.
Yes, madam.
Subject matter covered by judgment.
Yes, madam. I
Have you changed the factors?
have not changed my lord. I have appeared today, my lord, according to be decided.
Covered by which judgment?
Yes, judgment.
This
Exactly.
Your lordship judgment. That you should give for giving PIN number.
The subject matter of this intra-court appeal by the state and its officials is substantially similar to the one in writ appeal number 3422 of 2024, between state of Odisha and another versus Tapan Kumar Sahu and others, disposed of by this bench by the order dated 25/3/2026, declining interference, both on merits and delay. First off, even in this case, there is a long delay of 801 days, which has not been plausibly explained. First off, in the above circumstances, this appeal fails. First off, the appellant shall comply with the impugned order of the learned single judge within an outer limit of 3 months. Because learned single judge has given 3 months. Well, 3 months. Without driving the respondent to pursue contempt proceedings. First. 24 over.
25 same.
If I also same, but delay is
956.
956. Here, see this 956 days. Okay.
Item 26.
26, my lords, this is Sarat Parida. But 598. Okay, previous one. Similar to 22.
26 is 20 rupees per case.
598.
Item 27. Writ appeal 1550.
So now I have filed a cabinet petition, copy of the writ appeal may be sought to me.
I'll serve.
One thing, my lords. Another writ appeal, my lord, that is a pending before the my lords.
Call along with the.
That is in the list, my lords, week list 91. Maybe taken up, my lord.
91.
91.
Shift to daily list and call along with this.
My problem may be taken up because last 10 years, my lords, we have
Yes.
Along with my lords, I am giving another.
My lords, here 27 contempt is fixed to this week, your lords.
In this case.
Contempt, my lords.
But don't precipitate the contempt matter.
Contempt, my lords.
This is decided.
May
Till next date of hearing, the contempt proceedings, if any, shall not be precipitated.
The date may be with the last.
Therefore, you have said that. In the first week of May.
In the first week of May.
There is a list in the material in the list, my lords.
We understand.
Maybe some.
It is already brought to the
Any specific
supplementary.
date, my lords.
11th of May.
I'm just giving the number, 2 numbers.
Do that.
Item 28.
Call along with that.
Writ appeal 1903 of 2025.
This is also Sarat Parida, my lords.
20 rupees, 796 days. Yes.
Item 29. Writ appeal 33 of 2026.
I'm appearing for the respondents.
Yes.
Last order, let's see the delay of that you said that we are filing also objection, but
220 days.
yes. But what I pray, you're also here on merit as well as on limitation.
Delay hours.
Yeah. It is too long.
My lords, Mr. Fonda
Fonda is not here.
must be in virtual mode. Lottie pass over.
My difficulty is at 2 o'clock, another matter has been fixed.
You complete and come back.
Yes.
After you come back, just mention.
No,
Take up. Possible. Unless you want it some other day.
No,
If
we
you
want
want some other day, we'll fix that rate also.
Can it tomorrow?
Tomorrow we have difficulty. We will have it on the 4th of May.
Let me try. We're after lunch because of.
Item 30 has been adjourned. Item 31. Writ appeal 1907 of 2025.
Thank you, and for the respondent minutes. May they have some time to file the minutes, reply to the additional review.
Take the chapter.
You want to
No, he's for the.
Not different. Next item. Call after 2 weeks at the request of public. Yes.
Item 32, Minute Appeal 2970 of 2024.
Yes.
I am the appellant, my lord.
Yes. But who is your friend?
Well, I am appearing for bank.
You are ready?
Yes, I am ready. But if your lordship, if it will be passed over after lunch, my lords, I will be present physically.
Any other date you want?
No, my lord.
Okay.
Physically, I will be there.
Yes.
May it please your lordships.
Yeah. Yes,
There is an appeal by the state, my lord, challenging the common order, common judgment, and dated 11/3/2025 when passed in 8 identical writ application and numbered in the cause title, my lord, at page 349, the judgment stats. 349, wherein, my lord, the honorable single judge opined that in view of, in the absence of showing any provision that finance department concurrence is required to implement the decision of the OPA. OPEPA is a society registered under the Society Registration Act, and through the OPEPA, the government, central government and the state government, they implement the Sarva Shiksha Abhiyan primary school education program, my lord. And the fundings are 60-40 ratio.
60 by central,
60 by central, 50 by the state. So the OPEPA has a memorandum of association and article of association, and they have got an executive committee which takes the major decision of the OPEPA, the governing internal governance of the OPEPA. Now they have in their 30th executive committee is availed at annexure that the connected
ground is
foundational
of state government, the finance department is required or not?
Yes, that is the sole question, my lord. And that is governed, squarely governed under the rules of business of the government of Orissa, Rule 10, where the finance department concurrence is necessary, where the financial implication is there, burdening the state exchequer. And yes, is a must. That was not taken. Rather, it was in the 36th meeting. It was this same executive committee of the OPEPA sought for post facto approval of its 30th, having the financial implication. Both the executive committee resolutions are before your lordship at annexure. Lordship may see the connected writ petition. I am just drawing your lordship's attention.
The
petition for implementation of the 30th executive committee resolution, which has specifically enhanced the salary and the emolument components of the OPEPA employees, having huge financial implication, and it was continued for a particular period of time from 2014
2014 to 2018. In 2018, when similar occasion arose for the OPEPA for further enhancement, they sought
policy where 60-40 emerges, whether state government is a party to that policy.
Yes, yes,
party.
Yes, integral.
Where is the question of state is a party? The department is bound to give concurrence. Where is the option? Does it say this 60-40 is subject to concurrence of finance department?
They cannot, they are so much to enhance whatever to the extent they are at pleasure, they to enhance the component, salary component. No, my lord, if at their fancy they will continue to enhance the state government will bound by that, my lord. Not, it is not within that 40-60 ratio for the preliminary that expenditure. But the salary component, it always will depend upon the finance department concurrence. So Lordship may kindly have a glance to Rule 10 of the rules of business of the government.
No, that is society.
That your Lordship knows. That your Lordship.
You are saying economic federalism.
Economic, yes, my lord. My lord, if they will, at their so much, at their whims and fancy will continue.
They increase. No,
it's a parallel. It cannot be as a but treat itself as a parallel government, my lord. State exchequer will give the money to them and will not have any regulatory power. Will not have any, and the rules of business will cease to operate in that domain. My lord, it is inconceivable, my lord, in a democracy, my lord, in the state exchequer will be burdened at the whims and fancies of a society which claims the independence, financial independence, my lord. And when it was detected later on, the same.
You are trading the idea.
Yes,
so we have to treat the idea. Be slow. Give us time to process what you are saying.
Yes.
Where is that 60-40 policy?
60%. That is not disputed. That is our.
We want to know.
My lord.
We want to know how 60-40 policy operates.
One of such example, my lord. Here a document is not part of it, my lord, is going to clear from here.
What is part of the document? Record?
No. Because that was not disputed. How the money is, my lord, how the 60 and 40 money comes to the society, and before it comes, that is. My lord would find from the last 12 lines, finance after the concurrence that comes to the society for expenditure.
No, what we want to know you, 60-40 policy, how it operates. Where is that 60-40 policy? We want to see that.
It's mentioned here in one of such cases, which I just gave, may I place that? This is release of first installment of fund under Sarva Shikha Abhiyan, this society. For Orissa for the financial year 2015-16. I am directed to convey the sanction of governor to the expenditure of such and such as recurring expenditure consisting of only 50% of central sharing amount to such and such, state share amounting to such and such.
No, and 50% state.
Again, the next sanction order, this is for a hostel under the same society. This expenditure is called KGBB, my lord. That's why the my lord may kindly come to the next order. That is clear, 60-40, it's there. That is for the year 16-17. My lord, the next page. Release of balance first installment of funds for implementation of Sarva Shikha Abhiyan SSS scheme in Orissa during the year 16-17. I am directed to convey the sanction of governor in an expenditure such and such, only as recurring expenditure consisting of only 60% central share amounting such and such, 40% state amounting to such and such. Man, this is the installment which government has given for this 2016-17, and my lord would find from the last line, last line. This has been concurred by the finance section juncture. After the concurrence, the part of the state government and the part of the central government comes to the fund of the society, that is OPEPA. Now it is OSEPA. It was dealing with primary education, now secondary education has been included. Man. So what is that the case that 40% which the state government has given to the society, after this enhancement of the salary, does it exceed that 40%? That is never the case, because
40% percentage is not altered. But so because of the enhancement of the salary,
it includes that 40% with the government, central government 60% and 40% of state government. It's an unit.
There is our constitution, Dr. Ambedkar said, our constitution contemplates financial federalism also. Financial federalism means what center will spend, the state cannot be compelled to spend. No, it will take the decision depending upon the availability of resources.
But here is a case that there is no enhancement. The money is 60% and 40% is they give it to the society for the year, subsequent year.
It's a writ of arising out justified by the state against the judgment passed by the Honorable Single Judge. That's the case regarding the emoluments and the parts received by the OPEPA employees as per their bylaw and guideline. As per their bylaw, they were all appointed with the specific government condition that their pay and emolument would be at par with the employees of the state government. That's the specific bylaw of theirs and also the state government's decision. In terms of that, they were being paid from the date of their appointment. All of a sudden in 2019.
That OPEPA is a state society.
It's a scheme. Yes.
Scheme.
Yes.
Who was the petitioner?
We are the employees. Of course, we stand on the same footing. Employees, you have the petitioner before this Honorable Court.
Yeah.
The background of the case is, as rightly Mr. Roth said, in 2014, they are governed by the Memorandum of Association.
Yeah.
Memorandum of Association binding to both. And Memorandum of Association.
Both means who?
But Memorandum of Association, in fact, the state has made that Memorandum of Association, where the Chief Secretary is the chairman, and the other secretary, they are also the members.
And central government. With central government.
Yes. So the whole question is, in 2014, a decision was taken that the 30th Executive Body meeting, where the Chief Secretary, under the chairmanship of Chief Secretary, or should kindly see that, they have decided that in terms of the memorandum, that whatever benefit marks are getting state government employee, the same benefit will be extended to these persons. Page 105 of the okay. Page, kindly see my the office order, that is at page 100 and this is 55 no, 155 no, of the appeal memo where I'm appearing. 20th of September 2014.
There are four matters.
No, this is
two matters. First matter will 33.
This is the of 2026.
40. Second one.
No, one just document I'll show you, Lordship. Your Lordship will find the entire issues of them.
Can you show us what is that 60-40 principle? Where is that? How that those terms that instrument operates?
It's there. The 60-40 central government will bear 40 settlers, 60.
No, this memorandum of particular or bylaw, whatever.
Yes,
is there.
Yes, it is there. It is there on record. It is there on record.
Where is that?
That bylaw.
Then there must have spoken about the constitution of the body.
Yes, that is that is that. Kindly see. This is the bylaw, page 324. It starts from page 324.
bylaw of the society.
Yes.
What is the constitution of the committee? How the society is constituted?
Exactly. This is constituted under the provisions of the rules and regulations we called as rules in Odisha paper. Odisha Primary Education Program Authority Rules and Regulations.
No, that is there, but under society or
Society registration. Society Registration Act 1860.
1860. Who registered it?
But must be IGL. It has just throughout the state operation, it has to be by the IGL.
No, can't assume. You have to show it, to demonstrate it to the court.
I'll have to demonstrate. The registration part is not available. It's not readily available with regard to registration.
Who are the office bearers of the managing committee members?
Yes.
Who are they? Who registered this society?
Kindly see my lord, page 326.
326.
Right. Chief Minister, Minister of School Mass Education, Chief Secretary, not got it.
All governmental,
all governmental,
barring except co-opted people. So it is an Article 12 entity.
Yes. Yes, sir. At this juncture, and you are asking for Annexure 13, the 13th Executive Committee meeting, which is the crux of the matter. Now, that is the basis on which the benefit were given from 2014 to 2019. Let's just kindly have a glance.
Page number?
110, I think. Sorry, 141. 147.
In which read?
That is read appeal number.
Read appeal?
Yes.
Read
appeal number
30 or 40?
40 of 2000, yes. Let's get it.
Page 47.
Sir, 47. Sir, 47. Not right. Sorry. Let's look at who are
13.
Yes, yes, Annexure 13. Let's get it. You also look to who are the persons, because you also just now look who are the members of the governing body, executive body. Jugal Kishore Mahapatra is Chief Secretary, so Additional Chief Secretary, so Commissioner Secretary, Additional Secretary, Director of Elementary Education, Director of Mass Education, Joint Secretary, Representative Director, all these in terms of that bylaws. At this juncture, also
whether Finance Secretary was also a member of this.
Yes, sir. Yes.
Where is
yes.
that?
That is Department of HR, Additional Chief Secretary, Finance. You look to the second. So IS, Additional Chief Secretary, Finance.
Chief Secretary, Finance.
Now you also kindly come to page 100. Page 149. 149. Let's look to item number 6.1, career advancement of OPEPA employees.
Was it 49? It does not say that.
There are 150. That is extremely sorry. There is some state appeal they have given sub, so therefore there is some discrepancy.
No, that is in 150.
Yes, sir.
Career advancement of.
Yes, sir. Career advancement of OPEPA employees. With the employees of OPEPA. The recommendation of the committee constituted by the government to look into the demand of OPEPA Employees Service Association were placed before the Executive Committee for consideration. After deliberation, the following recommendations of the committee were approved to be implemented with effect from 1/3/2014. The base remuneration of different categories of employees of OPEPA would be fixed at par with the initial pay structure of similar type of post in the state government and with due recognition of the seniority and annual incentive at the rate of 2% on the base remuneration per completed year of service should be allowed, counted from 1/1/2006 or from the date of joining, whichever is earlier, as per the following statement. That is on the next page. This is the remuneration which was decided to be given. That is next page. Different type of employees are there. That will also kindly see from page 100.
So this is a recommendation.
This has been approved. This has been approved. Not only approved, it was extended. I will tell you. This was extended.
Approved by whom?
By the Chief Executive Committee.
Of the society.
Yes, that Executive Committee with the Chief Secretary is the chairman, all others are present. You also look again to that page, Annex 13, 30th Executive Committee meeting of OPEPA. 30th Executive Committee.
Chief Secretary come chair.
Yes, sir. Yes, sir. Finance, you also just now asked me the question, whether finance, additional Chief Secretary Finance was there. Then, sir, all were there. That is, also kindly remember, 30th Executive Committee meeting of the OPEPA held on 6/3/2014. Now, sir, 6/3/2014. Then you also kindly come to the page 155. This was extended right from the date when it was decided, that is from 1/6/2014, it was extended to the employees. At par with the
That your lordship will get.
Similar course.
Right.
That your lordship will get page 156, last para 5. An amount of equal to the PA enjoyed by the state government employee from time to time will be added to the base remuneration. Lordship will see the last line of this page.
An amount equal to the DA
enjoyed by the state government employee from time to time
will be added to the base remuneration.
Right, sir.
This is how they have allowed.
The base remuneration means basic pay.
But whatever the pay was been fixed so far, the basic pay and other remuneration, that will be same. That is in terms of the Memorandum of Association. Lordship asked Mr. Roth also.
Lordship will see that just above that, the entire thing calculation
is there.
Remuneration proposed, present remuneration.
Right. That very annexures, which was the decision of the Executive Committee. And that was extended, that was given effect to at page 155.
This is annexure.
As that is annexure 14. Annexure 14 of the writ application, but they have at page 155. In pursuance of the decision, also kindly look to that office order. It has been issued by OPEPA. In pursuance of the decision of the Executive Committee of OPEPA in its meeting held on 6/3/2014, the remuneration of the contractual employees, yes, all the contractual employees of the state project office and the district project office under the project management hereby revamped as under which is within the limit of management of so-and-so. So-and-so was duly approved by so-and-so, MHRD and so-and-so New Delhi. Does you get it? Then you also see this was extended with effect from that, with effect from 1/6/2014. And then there was no call over that. Now the impugned order you also kindly see, but all on a sudden, that you also kindly see page 174, which was the subject matter of challenge before the Honorable Single Judge. This is who has passed this order? Special Secretary to Government School and Mass Education. An order was passed on 1/8/2019 after 5 years. The benefit which was extended. No notice, nothing. The Odisha, let's kindly look to this. But they have said the Odisha Primary Education Authority was constituted in the year 19so-and-so. It also skip over. The current remuneration structure of persons engaged in the society was finalized by the 30th Executive Committee constituted at the level of OPEPA and passed in the Executive Committee. However, Finance Department concurrence was not taken, although the state bears 40% as per the scheme structure.
Yeah, your lordship will get 40/60.
But what is practically the current contribution of the center would amount to much lower than 60%. However, the sharing pattern of the center and the state since finance year 2001-2 has been reduced from 85/15 to 60/40. At present, the employees of OPEPA.
Earlier, the central government was on 85. State government was given 50.
That is what.
Now that has been reduced to 60/40.
60/40.
That is what they say. That is. Then at present, the employees of OPEPA are drawing their remuneration as per ORSP Rule 2008 by their office order number, which is just now read, 7970 dated 29/2014, without the approval of the government and concurrence of the Finance Department. Further, it is to mention that the employees of OPEPA are schematic employees, but they are drawing gross remuneration at a higher rate. It is not correct. It's not higher rate, as Mr. was saying. It's not higher rate. Let them say that it's a higher rate. No. It is rather the same rate as in 2014. Now the single judge has allowed that rate only in 2014. Further it is mentioned, paper and schematic employee and they are drawing gross remuneration at a higher rate due to addition of certain perks, which are not extended to any state government employee. The dynamic day structure twice a year is not available by any schematic employee of the state government. Due to gradual decrease in central functioning funding, the financial burden has also increased of the state government. After careful consideration, they have decided government to freeze the existing remuneration at the current level with effect from 31/3/2019. Now in the counter, they wanted to develop this is their case, saying that in 2019, because that memorandum clause for 45 has gone on amendment, because the require of the state government is required. They have made an amendment in 2019 that any decision to be taken that requires subsequent approval by the state government. But that came into force only in 2019. The decision was taken in our case in 2014. There was absolutely no bar under the memorandum of association or bylaw, whatever one may say. Rather, they themselves have taken such a decision. And all the officers, right from the chief secretary and the additional chief secretary, who is also building the Department of Finance, all have they have taken this decision. In terms of the memorandum of association, if you also look to the memorandum of association, they are entitled to get at par with the perks which are getting at their counterparts in the state government. Yes.
So in fact, the state government filed an affidavit for the Honorable Single Judge that they are going to implement it. For the Honorable Single Judge, when he raised the question of they filed an affidavit that we are implementing.
They filed an affidavit in a contempt application. They filed an affidavit. We are implementing the judgment, but they say that we have constituted a committee to fix a particular norms, which is not in consonance with the direction of the Honorable Single Judge. So the Honorable Single Judge said that is not in consonance with the direction.
What happened in contempt?
Contempt is pending. Your Worship had passed an order last occasion.
We are not pursuing it.
We ourselves said from our side that we will not pursue that. You also hear this matter. And that you also have recorded that also.
Now, one aspect is,
yes, sir.
Earlier, the ratio was 85:15. 85% used to come from central, so 15% from state.
Yes.
This has been now downwardly revised to 60:40 for the center, upwardly revised to 60 from 15. That is 3 more times it has been increased.
Right.
Liability.
Right.
That is, they say our purse is affected.
Sir, that is not the case at all, sir. No, I have seen
That
also.
is the order. The order of the Secretary of the Finance Department says it will be extra burden.
Sir,
because earlier it was 85:15. Now it is 60:40.
Sir, now the question people worship is, if the memorandum of association clearly, which has been prepared by the government and registered of the Registered Society Act, all have accepted, and they said whatever benefit is being extended to state government employees, that will be extended. That is the memorandum of association, that is the rule that is binding. You also know that even by law. Just so that is a different question. Sir, now they themselves have taken a decision in the executive committee meeting and 30th meeting in 14. Now, can this special secretary to government of school and mass education, can he alter it, saying that all these things? And as my one friend rightly said, that 40% that is also not correct. That has been also answered. That I'm not in a position to give you also answer.
But you said before you came here, it is within the limit of 40%.
Yes.
We remember that.
It was there when probably the decision was taken, that was there.
The entire project was for suppose 100 rupees. For a particular year.
Then it was not 40%, no? Then it was 15%.
No.
60/40 was made on which
but there is an amount which is fixed by the central government and state government which will be spent on the project for a particular year. And that is always fixed, my lord. It is not their case that enhancement will model the government. It always is within that limit.
They are not giving any date to 40%.
Yes, 60/40.
My lord. Chief Secretary is a party. Additional Chief Secretary who happens to be the Principal Secretary of Finance Department.
In dual capacity, my lord. In OPEPA, they are having some different capacity. While Chief Secretary, he is having a different capacity. That way
He is sitting not as in the capacity of finance.
Not in the capacity of
member.
Financial, yes, as a member of the OSEPA, that executive committee member. Chief Secretary may override that finance secretary.
Once this order is issued by the OPEPA, has to go to the finance.
Yes.
But by then the fund has already been sanctioned and brought to the...
That's why my lord, I may not be disturbed. Now they have completed the submission. Your lordship may grant 5 minute times to answer to the submission of the respondents. My lord, my lord, yes.
A society is not an incorporated entity. That's the law.
That's the law.
Although it can sue or be sued is another thing. It is not like a company. A society is an association of people.
Article 19.
Right to association. The government formed this society, registered its society. By registration, incorporation does not happen.
Doesn't.
Therefore, those who came from the government as the members of managing committee, it is nothing but notional extension of the departments of the government rule. In one Karnataka case, it was a lawyers' club where wine was supplied. They were members of that club. Club sold the wine to the members, lawyers, maybe in the Friday evening. Question was, in Karnataka, there was a law, Second Sales Tax Act. First, when the club bought, that was the first sale, sales tax was paid. Now, club is selling it to others. Therefore, the second sales tax has to be paid. Justice C.S. Venkatramaya, great Chief Justice of India also, as a judge of the Karnataka High Court, said, an association is nothing but a name for the collectivity. When collectivity gives the wine bottle to the members, it does not sell. It is not a transfer at all. It is from one hand to another.
The fellowship.
Therefore, there is no sales tax at all.
That is there, my lord. That I clearly understand. Yes.
If that is so, where is a kind of lifting the veil it is now?
Yes, lifting the veil.
Lifting the veil. Yes. See, who are all the members of that?
Yes, I've gone.
Whole government is...
Yes. Now the array of the opposite party, lordship, in which capacity they have been parties? Only in the capacity of OPEPA. State is not a party there. State government through the chief secretary is not a party. OPEPA executive, chief secretary is a party. OPEPA executive, the finance secretary is a party. And my lord, my humble submission before lordship, the main lord and senior counsel, my lord, conveniently relied upon the 30th resolution of the OPEPA. And he's harping upon it, he's banking upon that resolution. Now the 36th resolution, lordship, which was conveniently not shown to your lordship, 36th resolution, 159 page, annexure 15 to the writ petition, which is also annexed at page 159, running page. That is the 36th meeting of the executive committee, where the same executive committee, my lord, it starts from 159, and the relevant clause is, resolution is clause 9 of that resolution at page 165. Your lordship may kindly have a glance. Enhancement of salary. What prompted that secretary, school and mass education to pass the impugned order, to freeze that? It is the same OPEPA executive committee which went before the government seeking post facto approval of its 30th resolution, my lord. And the post facto approval seeking was torn down by the finance. Therefore, it prompted the school and mass education secretary to freeze the emoluments. And placing that 9, enhancement of salary, remuneration, structure of employees working under RT, SSA and KGB, notification of salary structure of employees of OPEPA engaged under project management head of RT, SSA. The employees engaged under OPEPA project management heads and state and district level are availing base pay plus GP plus DA plus other allowances as available to them, their counterpart at government level, as per the decision of the 30th meeting of the Executive Committee of PEPA held on 6/3/2014 with effect from 1/4/2014. They are also drawing the enhanced DA as enjoyed by the government employees from time to time. In the meantime, Government of Odisha has allowed salary. The committee also suggested to conduct the human.
That page has
but I am having that page which is annexed in the writ petition as Annexure 15. Annexure 15 writ petition, Your Lordship may see, the connected writ petition. I am drawing Your Lordship attention directly to the writ petition.
The page 165, running page 165, internal page 7. Next, one internal page.
What ultimately
My lord, just I'm reading. My lord, I'm just reading. That is the matter. Hence, enhancement of salary.
They had sought for post facto approval.
Yes.
Long and story.
This goes
the matter relating to existing employees working under the SS and the state. May I just read? Discussed and the committee suggested to put up the matter before the government in school and mass education department to examine in consultation with the finance department relating to exist 6B. This is the B, my lord. That
wrong document.
No, not document. The same document I'm reading. Six. It clause 6.
Mr. Panda, please follow. If you are read just now 9A, again I'm reading because the continuation.
Yes, 9A.
The employees engaged under OPEPA project management heads at state and district level are availing base pay plus GP, grade pay plus DA and other allowances as available to their counterparts at government level as per the decision of 30th meeting of the Executive Committee OPEPA held on 6/3/2014 with effect from 1/4/2014. They are also drawing the enhanced DA and enjoy government employees from time to time. In the meanwhile, Government of Orissa has allowed salary as per the recommendation of the 7th Pay Commission.
Yes.
Hence, for employees engaged under project management, head of the state and district.
Same benefit has to be extended.
Yes. And necessary budgetary provision has already been made. You also see the last line. Necessary. Oh, sorry. My lord friend's brief is not carried.
No. I am reading B. Capital B.
That page.
They are reading A.
Sorry, madam.
They are reading A.
Correct, but budgetary allocation is also paid.
Not there. Lordship, see, I am just reading. I am just pressing. The matter relating to existing remuneration of employees, that is capital B. The employees working under SSA and at state, district and block level was discussed and the committee suggested to put up the matter before the government in school and mass education department to examine.
That is not.
No, we are not.
My lord, that is not in
Sir, kindly look to this, sir. Because
page which is missing.
Sir, kindly Perusa. That E is something different.
That page itself is different page.
My lord, it is a clause 9.
That's from the previous.
Enhancement of salary, remuneration structure of employees working and A is by employees.
No, why a part of the latter part of A, the committee also suggested to avoid automatic assumption of approval of executive committee on various issues relating to financial in nature without concurrence of finance department, since invariably there is 40% share of the government in SSA project and government have to shoulder the entire liability after closure of the project.
Yes.
So far the budget provision is.
This doesn't exceed 40%.
And you also look to that budgetary provision.
Budgetary provision has already been made by the PAB Government of India under SSA during 17-18 following that due procedure.
My lord would find my read petition also. The second prayer is according to this decision, it should further be enhanced as per 7th Pay Commission. That is my prayer in the read petition, my lord, the first case.
So what is applicable is 9A. 9A.
Finally, the next page is not there in my file. The next page, that is
Next page is 9B. It is not concerned with your employee. That's
Yes.
all. Mr. Bhatta, even budgetary allocation has been made for that.
I have to seek instruction on that,
No, in writing it is.
In writing, still then clarification is necessary because we are taking a different study in contempt will not. In contempt will not, that compliance affidavit we have filed seeking that the EC has considered the matter and EC has a one-time enhancement 3%. We are sticking on that will not in contempt. Now, before this will not be budgetary allocation, the state cannot take two different stands in two different forums will not. I have to get clarified and come back to your lordship next week, my lord.
Next week we'll come back.
Yes.
After budgetary allocation, can you take up that stand?
Yes, is that because we
from 2014 till 2019 they extended the benefit. Suddenly they stopped it at that too.
Whether they were given opportunity,
nothing.
Because executive committee itself is granting and itself is withdrawing, my lord.
Did that be at all?
Employees, my lord. Employees, my lord, through executive committee they operate. They are not challenging the executive decision.
Members of the society. They are employees of the society.
Yes, employees of the society.
So the executive committee has withdrawn it. No.
That I will clarify.
Two things. Even these members who are in the society, as you said, chief secretary is not ex-officio member.
No, not
He is member as chief secretary.
That's your secret.
Then chief secretary will take a different stand overriding this rules of business.
The very object is sending all the
even chief secretary cannot override, even the minister cannot override the rules of business.
Now, once finance secretary, chief secretary,
statutory procedure has to be followed sacrosanctly.
But will you not follow the procedure when you withdraw?
Yes.
Then you have withdrawn without the opportunity of hearing.
Opportunity of hearing to whom, my lord? To OPEPA, my lord?
No. To the employees you have to give because you are withdrawing that salary.
It's a
Which numbers of employees? 1,100 employees, my lord.
Maybe 1,000 people may be there. What to do? We have to hear.
It's a benefit.
Because it's an illegal benefit if they are drawing, my lord. I'm relying upon a decision of the Supreme. So I will place that decision. If illegality cannot be perpetuated.
That means whether there is illegality or not, should it not be decided after giving opportunity?
That part may be there. That part may be there, my lord. But for 1,100 so-called notice will be.
You should notice by the paper publication. That's all. You need not legal notice. By paper publication, you could have
that part is not complied with. That part is not complied with. I admit.
Sir, with all respect, I can say. So far, the executive committee has never taken an initiative. That is the sole question for the single judge.
Single judge, unless
see your counter.
No. Honorable single judge has judgment has premised on 8.2. Your lordship may see paragraph 8.2.
If you want to do this test,
no. Paragraph 8.2, my lord, the honorable single judge specific is that we asked a question to the additional government advocate that
to show where is the requirement of concurrence of
and not so. That will not as an estoppel, my lord, that will not operate as an estoppel. If that is the procedure is there, my lord, your lordship is to consider in appeal. On that ground, my lord.
Once budgetary allocation.
That part I will come. That part will even I need to file an affidavit. Whether budgetary allocation is already there or not, then we'll have no case.
We'll record your submission.
Yes, also file an affidavit.
The rest of the things will pay it.
Yes.
Let him say that.
Yes, we will say. And that rules of business where, my lord, that is our trump card in this. We are seriously banking upon these rules of business. Procedure cannot be bypassed even by the chief secretary and the finance secretary. That is our sole, and we will rely upon certain decisions of the Supreme Court.
No, if decision is taken by X.
Not sitting, my lord.
If decision is taken which will have financial implication by body X, that requires approval by the finance department. If the finance department secretary himself is sitting in that body,
in
that
many,
it
many,
is doubtful.
in many occasion, he
Other
is sitting in.
capacities you are saying.
Yes.
They are company boards, statutory boards, etc.
Finance-
Society, it is not applicable.
Financial implications, it is to go by the procedure itself and move before the cabinet. And ultimate decision is to be taken by the cabinet.
How many years you have given this benefit?
5 years.
5 years.
From 2014 to 2000.
Any objection was raised?
No,
in the
nothing,
audit?
nothing.
Every year, government is audited under Article 156 or 150.
It is there, my lord. It was when it was dictated.
Every year, controller and auditor general.
CAG.
CAG, state audit goes, the scrutiny at the hands of the CAG.
CAG, perhaps it is accountant.
CAG, then it goes to CAG. All state governments will be under the scrutiny of CAG. The object of that one.
That was not
any objection is raised by the CAG or by your age auditor general.
That I will come back. Specific question, Your Lordship, may
Mr. Panda, having vociferously argued the matter for some time, seeks a short accommodation to come out with the answers as to the following questions. One, whether there was a budgetary provision made by the PAB of Union Government under SSA during the year 2017-18, which should cover the enhancement of salary and emolument pursuant to the committee resolution of the committee meeting. Resolution of the committee passed in the 30th meeting.
6/3/2014.
6/3/2014.
2014.
Next, whether any objection, audit objection was raised by the CAG/AG as to the allocation of enhanced pay structure to the employees of the society on par with their counterparts in the government.
Yes.
For the last 5 years, preceding the order impugned in the writ petition. Question. If answers to these questions are in the affirmative, they will cast their shadow on the prospects of this legal battle.
But Your Lordship may kindly take into consideration our submission regarding the rules of business, bypassing of rules of business.
No, that also will cover.
That also,
Your
Lordship may kindly
to note that here.
Note, yes. My submission, my contention.
We are ready to.
My contention.
We are ready to examine deeply.
Grateful.
The contention of Mr. Panda that under Rule
10 of the Government of Orissa Rules of Business. Rule 10.
Rule 10 of Government of Orissa
Rules of Business.
Rules of Business. As to the requirement of concurrence of the finance department to any decision that would include financial implications on the state budget.
Yes, my lord. Grateful.
My lord has raised several contents of one contention I am raising. If you are also recording them. question for consideration before the Honorable Single Judge and the rightly answered also. If a power has been conferred on the executive committee to take any decision with regard to the service condition of the employees of OPEPA, and in fact, in exercise of such power, they have taken such decision, and that decision having been implemented for 5 years, can the School and Mass Education Department
now turn around and say that we will not touch?
Yes.
Whether recovery is also ordered?
No. The recovery has not been done.
They stopped with prospectively.
Yes, prospectively.
Only that is our.
The similarly, the moot question raised by the from the side of the employees that once power is given to the managing committee of the society to take decision as to the pay packages, and such a decision having been taken and further implemented for 5 long years, can the state,
one department, School and Mass Education Department,
through the Department of
no, Department of School Based Reliance Finance turning down that has been mentioned below.
Department of Finance,
Department of Finance
contained that the concurrence having not been taken, the benefit of revision pursuant to the 30th committee meeting resolution dated 6/3/2014
was ab initio our ground.
Continue. Also needs to be examined. Okay. Yes. Day after tomorrow?
No,
or we forget? How survey your government? This question. Whether they started objection, that will be reflected in the computer.
Voluminous examination is there required. 7 days, at least 10 days, 10 days time.
10 days?
10 days.
Take 1 week.
No, Lordship never forgets anything. 10 days you
No. 6th May.
My lord.
May not be next week.
No.
Next week, we also want to board. We have posted many medals.
No,
That's the-
I
No, any of this is the we have understood. The matter we have understood. You have to bring. I do not know that decision of Justice K.S. Venkatramaiah under the Karnataka Sales Tax Act.
Just I have already told my associate to find out.
Number 1. Number 2, where the state government establishes the society.
Yes.
And sends its own officials as the managing committee. Whether such society is notional extension of the
state government
itself or not.
State government itself.
Itself or not. There are judgments from which are arranged. Yes. And thirdly, whether doctrine of lifting the veil that operates in the corporate extends to cases of this kind.
Yes. Will be immensely benefited by your lordship judgment. That way will both the sides, fellow. In the bar.
Just 5 years you gave.
Yes.
One fine day, secretary dreams something and says, no, it cannot be given. By oracle, if he takes a decision, Rich court cannot cannot be a silent spectator.
Only thing that the rule is coming on the way.
Is the case.
Item
32. Rate of it 2970/2024.
32. My lord, if a crossover may kindly be granted, my senior is badly placed in another adjacently placed in another.
Is there difficulty in that case? Why are you using the word badly placed?
Badly placed as in the current situation, right? The case is in that scenario.
Item 33. Rate of 3071 2020.
I'm just making a mention, my lord. Item 33, perhaps, my lord, I have talked to the Lord Council for the other side, the appellant, my lord.
Mr. Das, yes.
I am here. He was requesting, I was just requesting him, he was accommodating me for today. We both agree, my lord.
Das generally will not accommodate. No, he's a very strong soldier.
I have been able to pursue my learn problems. Elder brother, my lord.
On the same day, when we have posted that matter, no? So all these matters. Oh, good.
Item 34, rate of bill 3354 of 2024.
My lord.
Yes.
Compulsory judgment. There is no matter of placed for the review committee. There is nothing, my lord.
Matter of promotion.
Compulsory retirement.
This is a premature retirement.
Under a state like rule 56 of EFRA.
This is 71A.
71A.
State rule.
State rules, my lord. State rules.
Yeah. How many years of service he has put in?
I have put in more than about 30 years of service.
30 years?
30 years of service.
How many promotions he earned?
One promotion.
In 30 years, only one promotion?
One promotion.
Any disciplinary inquiry?
Exactly. There are two proceedings of pending, my lord.
Pending?
Yes, madam. They are pending. They have just initiated the department proceeding, my lord. No inquiry. I submitted the reply. But they didn't conduct an inquiry, my lord. No inquiries were appointed. And those two matters were taken as factor for completion.
By that time, how many years of service he had put in?
I have put in 30 years of service.
No, by the time the inquiry was initiated.
The district action was initiated.
First inquiry of 2019.
2019.
1710 million.
26 years, madam. Yes.
Yeah.
Put in 26 years. Sir, there are government software, my lord. It is directly about that.
No, we are asking these questions in the light of two decisions of the apex court.
Yes, madam. The lordship also decided the case.
That judicial officer.
Judicial officer, that is all.
That inquiry was constituted.
Yes.
But we did not complete the inquiry.
Two inquiry.
No inquiry was never.
We'll see three.
Well, this is two.
Two. Why that inquiry was not accomplished?
Well, one is of origin of
compulsory retirement to dispense with the inquiry.
Well, one is of 2019.
Correct.
1710-2019.
What was he?
He was an assistant conservator of
SCF. And the second inquiry is?
1711-2020.
Exactly 1 year. The first inquiry is 1710-2019.
Exactly. 1 year.
Exactly on 1711-2020.
1 year, 1 month.
1 year, 1 month. 1 year, 1 month. Right.
1 year.
What was the allegation?
First page 19 years.
Do you have a copy of that judgment, South's judgment?
Yes, madam.
Did it go to apex court?
That has been.
Anything happened?
Anything happened positively, my lord. Has to join.
It has been set aside.
Yes.
This judgment is set aside by the apex court.
10 days back.
10 days back.
Sanjay Santo. Yes. 10 days back.
That
1 year, 8 months or something left for service.
Do you have a copy of the judgment?
I have the soft copy. Soft copy I can make a copy today itself.
Then look into that judgment and come.
Tomorrow, my lord. Tomorrow I will.
We also will read that.
Today I can supply it.
Put it on 5th of May.
Little earlier paragraph. Some other grounds are there, my lord.
No,
Some
we
other.
will look into.
Yes, ma'am.
But we want to know on what jurisprudence it has been structured.
Yes,
Just we want to know that.
Little earlier, my lord.
Before that, number of matters, four. Earliest.
That is 15th.
There is no other. Even if we'll keep it, I don't think that we can take it.
I'm trying to collect it and supply.
Do that copy. Send one copy to us. Collect that copy. Just take note.
I'll supply. Okay.
Item 35, Rate Appeal 48 of 2025.
48.
No, 35.
Yes, Mr. Munshi.
Your Lord, it's a state appeal challenging the order, and the crux of the point is about the regularization of the petition on opposite party.
How many years of service?
Initially, since
How many
93.
years of service? Whether complaint as to the performance of duty.
Exactly.
3 years.
Initially on 2/7/1993.
33 years of service.
He was NMR, TLR initially.
TLR, then
in fact,
against the sanction. Since
in
1997.
July,
Jago.
Jago.
There was no sanction.
But recently the judgment.
No, that also doesn't speak about
It also does not speak.
this.
Fact remains. Yeah, Madan Singh.
That spoke something else.
Madan Singh and others. But they are reiterating the concept of Uma Devi and ML Kesari.
Jago also reiterated.
Yes.
But question is,
the number of years they have already served. Again, they have come back.
Correct.
Para 21 and
26, 27, my lord, Jago case.
Almost Uma Devi has almost diluted now.
Diluted.
Almost diluted.
by this recent area, my lord, from Jago to Dharam Singh,
Up to
and recently
Pawan Kesari to Dharam Singh versus Jago versus Shugopal to Madan Singh.
Madan Singh, though, tried to say about it, again,
Reverse nothing.
Here, my lord,
32 years of service here. 33 years.
Initially, bus conductor under the municipality, my lord.
Correct.
Not under.
Correct.
Subsequently, when the bus system was closed,
ONGC was abolished.
no, not true. The municipality have their own source. They are making their Baleswar municipality. Subsequently, they have adjusted on compassionate government as a tax collector. Then he continued as such.
But it's a continuity of service only. There is no break in service.
Similar, same scale, similar post.
And there is no such sanction post. Or even
sanction post.
Against sanction post.
no. Initially, no. There is no sanction.
3 minor not sanction post.
2/7/1993.
Otherwise, it's a basic because of Jago. But at least now show whether it is a sanction post.
No, my lord, 93 there is no sanction post.
No, 96 sanction post. You'll also time come to the writ petition.
Initially, they are under the Baleswar municipality.
Time come to annexed
Under the
Das can see, my lord. That post was sanctioned on 2/7/1996, my lord.
2/7/96.
96 post was sanctioned.
You gained entry on when?
93, my lord.
No, you joined on 2/7/1993 as DLR in the municipality.
There's no post
Subsequently, in response to the order of the Housing Urban Development,
Yes.
number 20577, dated 2/7/96, the petitioner was permitted to work on an ad hoc basis.
On
And by that, my lord,
sanction post.
in 93, that austerity measures was there. 12/4/93. They have.
We are not agreed with the argument at all in that electricity matter. We repelled this argument. And judgment is affirmed by the applicant. Our judgment is affirmed by the applicant.
It is my duty, my lord, to.
No, it was not you. Lenka had argued. Mr. Lenka had argued.
And
93. So there was no such sanction post because of the council has taken a decision to observe him as a conductor.
Will you not permit him to argue? You should resist.
I'm not against you.
Already adjust the mind of the court.
No, I have not.
First requirement of a lawyer.
It will also see the exact file.
So
Your requirement of argument arises only if judges are siding with him. When judges have not formed any opinion, allow the government advocate to argue.
So after 93, when the same was stopped, they have made an interim arrangement to accommodate this person in tax collector as per the municipality council decision. By the time, my humble summary, since 93, when there was no such post and austerity measures were there on 12/4/1993, thereafter this person has been accommodated. And in 15
austerity measure was during what period?
Since it is 12/4/1993.
But government itself took them.
Yes. The municipal council has taken a decision, they have accommodated the person.
No, but okay. But because you gave up all buses, therefore the services discontinued.
Adjusted.
Without any break.
On DLR.
Service municipal body apex court said is a local government.
You will be. Urban local bodies.
Employee of a local government, if sent to the provincial government, previous service needs to be counted. There are such judgments which Samaraditya Pal in his law relating to public service mentions.
And here it is the same establishment.
The same establishment. I cannot dispute it, my lord. But on compassionate ground, because there is no such post.
But then, so that's all. Dismissed on the following grounds. 33 years of continuous service with no complaint whatsoever. Argument of absence of sanction post would fail into insignificance, regard being had to the longevity of the service would be. There is no break in service when an employee leaves the local government and starts working in the provincial government or its departments. Notional break, if any, needs to be ignored. ML Kesari, Jago, Taran Singh, Jago, Madan Singh. Within 3 months. 3 months, compliance within 3 months. Oh, bless you. Yes.
Item 36 has been adjourned.
Not only that, ये matter may be kindly look into that austerity measure. After that, he has been in. That may be taken into.
No, during austerity measure that will not apply because you only have taken.
No, after April, my lord, sanction post, my lord, is rightly pointed out that.
That was in 97.
Yes,
the sanction post is in 1997,
but not in 93.
I was adjusted against the sanction post in
97.
But above all, the continuation of the employee since 1997 is as against the sanction post. And argument of austerity measure would fail into insignificance.
Item 37, Late Appeal 1779 of 2025.
Yeah.
In the meantime, there has been some development. Another coordinate single bench. Orders of one Hon'Ble single judge is being challenged in writ appeal here. Now, another coordinate bench of another Hon'Ble single judge has been pleased to pass a final judgment declaring the said order, his judgment, which is assailed here before your lordship, as
for inquiry.
Against that order, it has writ appeal is being finally argued. Finally,
we have the appellant there, my lord, and we have the opposite parties in the writ application. That the question was
whether in absence of a quantifiable data, there can be a reserved sentence can be given promotion. Here it is completely reversed, this case. Here it is reversed to the extent that it is a case where even though the reserve candidates were senior, they were not considered promotion as against general category post. So that is a second position of law from Savarwal to your lordship's decision. Then Justice Panigrai's decision, then Justice Sasikant's then there are several judgments of the Supreme Court, my lord. I just found out few, my lord.
Mr. Monty, let him start then. Let him argue, then let him reply.
That matter is fixed to finally argued on 27.
27.
Man, I was only
We'll call this matter on the fourth.
That matter, as I told you, what is that?
Post that we'll also get ready to assist you.
No, 27. That matter is, let him have the benefit of that judgment.
Yes, all those issues are there also.
27. Where that benefit judgment will not apply, Lord.
That we can say only after reading the judgment.
That will not apply because it is not a case of reservation in the...
There is some observation by one of the judges saying that the judgment is per incurium.
Yes. No.
There is some observation. You don't dispute.
But
in Hiranmay Naik case.
Hiranmay Naik.
Let's forget it. Your lordship's decision.
We will have the benefit of other wisdom.
Justice Mishra's decision.
So, all these things we consider on 5th of May.
After 5th.
No, I have strong objection in this matter because your lordship waited for years.
6th.
In the read.
Yes.
And it was made subject to the result of the petition. Then we got a judgment in our favor. Then your lordship told that case should not be disturbed.
We'll have
on 6th.
On 6th.
Your lordship. In the meantime, we'll post your lordship with the development.
27th minute, that is only for giving written notes for convenience of hearing will not
I think it's
on that day.
With great respect to our learned senior, court said that we'll hear on that day, give you a little notes also. We'll place it. Interim orders to continue.
Interim order.
Wait for it.
And I have been deprived for years together.
No, now you
in spite of my seniority. Let's hope that it is done in 6.
One connected matter is also there, Lord.
Which two matters are there? Three matters are there. Out of 3, 2 are arising out of the same judgment.
That logic matter has also come to this bench. It is before this bench. It has come here. Yes, there is a connected matter. It is tagged.
Lalit Naik's case.
So the case has not been tagged.
It has not been tagged.
That is.
This is Biswanath Sahu. The second one, my lord.
With
So
that case, no counter was filed by the appellant. This writ appeal. They did file in.
My lord, the second sub-item.
For an appeal.
Second of 37.
Exactly. 2395.
2395 of 2024.
There are 3 matters.
36, 37 to come together.
37 sub-item number 2.
No, 37 itself is not the item. 37 is also an item.
Yes.
And 37 sub-item is also item.
Yes.
And 36.
Yes.
All the 3 to come.
No, not 37. My lord, in 37, 3 matters are there.
Right.
2 sub-item is there and 37 is the main matter. Sushant Kumar. In 3 sub-item matters.
The service is not complete. Service is not complete.
The receipt showing service of required number of copies and AC not.
Sub-item.
With soft copy WP away. Have you received it?
Yes.
You have received it. Government side not complete.
See, in this government we have received. There are private parties ତମେ ପାଇଛ ପୁରା କହୁନ ତମେ ପୁରା ପାଇଛ ରେଜିଗ୍ନେସନ ବିଶ୍ୱନାଥ ଘୋଷ
11 are there. See, in item 37 itself.
Yes, madam.
Unserved notice for proforma.
Respondent number 9.
8, 10 and 11. Returned address is refused. So it is held sufficient.
8, 10 and 11.
Left without instruction, no such person in address. Letter to sender. Proforma.
8, 9, 10. They are all proforma respondent.
Proforma respondent.
Yes, ma'am. Can I have a glance to page 3, my lord, for a moment?
Refusal is sufficient. Refusal is sufficient. I have to see need for refusal is sufficient.
My lord, these 4 persons denoting the same persons in subitem number 2 is the petition. It is not required because there is two.
Who is there advocate? Who will request him to accept notice?
Mr. Rath.
One copy.
Mr. Palit is there.
I will serve.
Mr. Palit is there.
I'll serve.
He has to serve a copy.
Serve copy.
Learned counsel, so and so, requested to accept notice or
judgment to data from the
respond numbers.
My lord, respondent number 9 in the first item.
The first item. Then
there are 2 writ appeals.
In fact, my lord, 3 writ appeals are there.
Yeah.
In 3 writ appeals,
service to
it arises.
Respondents 8, 10 and 11.
Yes.
Is held sufficient in view of reported refusal to accept service. Okay. Learned counsel also shall accept notice for who are other persons.
Other persons were not appealed.
No, they are served, na? No, there is one person who is not served.
1 person left.
R4, R6.
Yes.
R4, R6, who are they?
R4 or 6.
Rohit Kumar Nayak and Rohit Kumar Nayak. It is no. One Rohit Kumar Nayak is the both
6.
Yes, Palai.
That you have to take for them. We can hold them as service submission. Right. Service of notice on R4 and R6 in writ appeal number 1779 of 2025 is sufficient. Since neither the postal cover nor the acknowledgement has returned to the sender. And therefore, delivery is produced. Come on, by resuming delivery. By resuming delivery. Okay. That's all. We'll have this matter on 6th of May.
One grievance is there.
Yes, sir.
In Lalit Kumar Naik's case, we were not a party in the main all those repetitions which have been heard. The learned single judge has declared us our judgment to be that is per inquiry, and which would not have been declared for inquiry.
Even if it is declared to be per incuriam, res judicata is not diluted.
No, I am not.
Judgment as such will bind you. Per incuriam refers to the expression of law in a judgment. But binding order
declared
intact.
Very strange that it has been declared.
Circumstances of my case,
it
will be confined.
Per incuriam,
But
are not considering
per
it.
incuriam also you have to see
Challenge.
to it that you have to challenge it and under what circumstances. What is the learned judge ignorant about?
There is no reasoning for declaring it. Except telling that the earlier judgment has not taken notice of Nagraj. Why should they take notice of Nagraj when it is a question of promotion to the general vacancy?
So circular
Nagraj did not relate to promotion of a reserved candidate to the general vacancy.
That is what my contention is. That there is a reservation in respect of the reserve candidate, there is a reservation in promotional post.
Then Nagraj applies.
Then Nagraj will apply the subsequent decision also.
Nagraj is Nagraj versus State of Karnataka.
Yes, sir. So that is in respect of 16(4)(a).
Correct. Amended the provision of the Constitution.
While upholding that validity, they told that but that is also, we cannot say whether how far superior
that judgment that was declared that
where the promotion is based on consideration of zone and seniority. Then the question of Nagraj, where from it will come? If there is a particular reservation for the reserve candidates, reserve classes, then quantifiable data will apply or not apply, whether there is a rule of specific percentage or not as decided by sovereign and subsequent decision. That will be arguable matter. But in case of post
promotion of reserved candidate to general candidate,
that just only question of merit. They will be considered. That's all. And to that extent, that circular took away that right. So it was declared illegal. So, and they never directed for promotion. They said the state should work out the promotion. So therefore, that judgment has no application here. Why that Lalit Kumar Naik case for inquirium, that is also, my lords, is illegal. That could not have been declared. I will say it could not have been.
That would be argued.
So the decision which declared another decision as per inquirium needs to be declared to be per inquirium. Till our decision is declared to be per inquirium by another court.
And that is why our High Court said, whether it is for ignorancia, either way, for ignorancia or for
in a lighter grammar, the argument can also be the reverse.
That is not what Mr. Monti.
No, all these issues. Since my Nagraj senior was submitting, I never wanted.
No, that Nagraj versus State was a case where promotion of candidates to reserved quota was involved. That arose because of amendment to Article 16(4)(a), 16(4)(a) during the previous regime, where they say right to promotion can be provided even in reserved category, which otherwise was not available.
Reserve category along with seniority also.
Of course, seniority.
That is challenged.
That is there the quantification.
And this is not just a...
For that purpose, quantified data is necessary.
Quantifiable data representation.
In fact, that is a quantifiable data in respect of the state of Orissa, but somehow or other it was not placed in the before the other bench.
Let us. We have got the rough idea now. What are the lines of arguments we have just noted? That they will not repeat it. We have already argued.
Your Lordship is fixing to 6th.
6th of yes.
I only pray that it may come top of.
We also pray the God. Let us see whether
let it be decided before that.
Either way, let it come on top of the list.
Let us see.
Item 32 also passed over. My friend has come.
Your friend has come?
Yes.
Yes.
Item 32.
Compulsory retirement matter.
No, madam.
No,
That's a dismissal.
Another matter. Bank employee.
Bank employee. Young lady, my lord, unmarried lady, bank officer. She remained unmarried to serve the caretaker on handicapped person, my lord. She was transferred from Odisha to Godhra.
Odisha to Godhra.
Godhra in Gujarat. Gujarat. As per the bank circular, the person employees who is caregiver to the parents, they are exempted from such transport, my lord.
How many children, how many sisters, brothers, siblings?
My lord, I have one sister, married sister, one brother who is not taking care. He is with his wife. He is living separately, my lord. I am the only person to take care of. That is the.
Kindly repeat the last two sentences.
My elder sister is married, my lord.
Elder sister is married and residing how many kilometers away from the parents?
She is at Rautla. Rautla.
No, your place of posting is here?
My place of posting was Kotak.
No, Kotak.
Kotak to Godhra.
Kotak to Godhra.
So elder sister is in
Rautla.
And brother?
Brother is married. He is Dr. Married is not taking care. He is living separately. Living separately is not taking care of.
But in Kotak.
Where is he?
He's somewhere in Odisha, but I have not taken. But
He's a doctor.
He's a doctor, my lord.
Doctor. It's the duty of the son to look after.
He's not. I have to. In this case, but the dependent proceeding was initiated, my lord, on the allegation of unauthorized absence.
Was it somehow my memory is telling that this matter was argued before us earlier?
No. Yes, I argued. He was not there, my lord. At the time of admission.
Sorry, madam.
At the time of admission, I was doing it, my lord.
Because
yes, at the time of admission, my lord.
Maybe at the time of admission.
At the time of admission, my lord. The inquiry was conducted, my lord.
You did not join the.
I did not join.
Your transfer order is dated. When did you join the appointment? When your appointment was done?
My appointment was in 2011, my lord.
2011, which date? Another thing.
26th May 2011.
26/5/2011.
11.
As
James, Junior Management.
Junior Management Cadre.
Yes, ma'am.
Scale or cadre?
Scale 1.
Scale 1.
Scale 1.
So thereafter, for 8 years, she was in Kotak.
Scale 1 is officer.
Officer, ma'am. Officer. I'm relying upon.
Transfer to placement.
Placement to Godhra region. That was on 29/6/2019.
2019.
Yes, ma'am. Your lordship, page 14. The resolution of bank resolution, my lord. Bank resolution.
No facts we want to know. Yes. She did not. Kotak to Godhra.
Godhra. I submitted representation to.
1 second.
It was in 2019. 19.
19, my lord. Transport, my lord. 29/6/2019, Annex 1, page 13, my lord.
She represented.
She submitted representation.
Saying,
my lord, that is representation. I should be exempted from such normal transfer, my lord.
You should not be transferred at all.
I was transferred from Bhubaneswar to Kotak, my lord. I was in Bhubaneswar and Kotak.
Either in Kotak and Bhubaneswar.
Yes, ma'am.
So Kotak you are already posted.
It is transfer from outside.
Yes.
No, under the banking rules.
Yes, I
This is
paid
all
for.
allowed, na?
Yes, my lord.
This is that famous judgment of Apex Court, that United Commercial Bank versus so and so. All scale 1 officers are liable to be transferred anywhere in the country.
Yes, that I heard. But as per the, I paid for exemption, my lord, in terms of Annex 2, page 14, my lord.
Exemption clause is there.
Yes, ma'am. Clause is there.
What is that instrument? Is it a rules, regulation?
It's a
Bank's regulation.
Bank's notification. Bank's. Now they have applied to others, my lord, but not. Page 14. May I read it, my lord?
This is the employees who are caregiver of disabled child.
No, man. Caregiver, dependent.
No, that is
who are caregiver of dependent daughter, son, parents, spouse, brother.
All are included.
All of this. All other.
This has got a statutory force because of Disabilities Act 2016.
Yes, ma'am.
Is it relatable to 2016 Act?
That they have referred it. But the fact is different, I will place one.
Bank has relied upon it and to give exempted to others, my lord. Of this region, Bhubaneswar region, my lord, they have applied this circular and given benefit to others, my lord, not to the petitioner.
What is the, if you not say allow?
Let me complete. And in my representation,
that again is subject to the administrative constraint.
Yes.
It's not an absolute rule.
Absolutely.
It's only a
They have since they have extended the benefit to others, my lord. I applied for
The
exam.
question is not that. See, there is a brother.
Yes.
There is a sister.
Yes, ma'am.
Why
I remained unmarried to only to take care
that
of.
you took a decision to be spinster is another thing. Bank has nothing to do.
Yeah.
Bank never told you not to marry.
And that's but now the bank's case, my lord, in the counter, this circular is not applicable because the disease support, my lord, is not within the parameters of this circular, my lord.
No, even other way.
Yeah.
Where have you stated in your representation? Have you stated?
Yes,
I have my elder sister. She is married.
I have not given
doctor. I have a doctor brother.
Yes.
And he has distanced himself from his house.
I have not
Where have you
stated.
stated?
I have not stated. I am only took care of my ailing father. I remained unmarried. That is the only.
Rakshanti Sthavire Putra. Putra should look after the aged parents. This is our ethos.
Anyway, they are proceeding. Inquiry was not. Inquiry was concluded within 1 hour, my lord.
How many? Very easy to launching of a satellite. You remained upset. They asked you why you do not want to go to Godhra. You said, I have parents. I have to look after.
Yes, ma'am.
You never indicated, disclosed to your employer. I have an elder sister, married and gone away. I have an elder brother who is a doctor, who has distanced himself from his spouse. There is none to look up. If your brother has distanced from his spouse, that's a ground for residing with the parents. Where is the bona fide?
Not taking care of.
But where are you stated? I have a brother who is not a good man. He does not want to look after my parents. I am a good daughter and therefore I will look. Where are you stated?
But
No. This is a writ jurisdiction. Writ jurisdiction is available to bona fide litigant.
Yes, ma'am.
Not for us.
For that, I have dismissed my lord. I have
Otherwise, tomorrow everybody will start doing it. See, we come from Karnataka. We have been transferred here. We have to
because they have extended the same benefit to others, my friends of the same.
That is get together.
Whether they had suppressed all this material which you have done. Then question of
That I cannot.
Where is your conduct? Your conduct does not satisfy the moral standards of Article 226 to 27.
And my
The morality, constitutional morality is also a fact.
The last disproportionate, rather than consider for any other
when you were dismissed from service,
then dismissed.
because you did not report for duty, banks need hands.
Punishment order on 30th April 2021.
30th April 21.
Yes, please.
Even then, it will not be 10-year service. Because you joined on 26/5.
Yes.
Even if we reduce it, we metamorphose the punishment order as a removal simpliciter. Still, that will not help you. No retirement, because 10-year minimum qualifying service is 10 years. And it's not a pensionable job also.
Bank pensionable service.
Pensionable? Yes, pension. But for pension, what is the qualifying service?
Contributory.
Yes, CPF.
And the only document before the inquiry officer you relied upon is the circular. No other evidence.
Nothing.
That is how he closed it.
That apart, it is not that your parents have no children.
Suppressed.
There is doctor's son. Doctor's son is better suited to look after the case.
That is the right, my lord. It is not because I am bound to take my lord because my.
That is not your case. That is not your case in your representation. Now, by your ingenuity, you want to make out that case, which you will not permit by our ingenuity.
In that case, bank would have called.
Bank would have said, or would have, your parents could have filed a complaint against the senior citizen act. Nothing.
Yes. Disproportionate crime.
What is disproportionate? You want to dismiss because she did not join.
Was 21 month, my lords. So it is in a banking service, my
You
lords.
could have removed. See, is there any tree nearby your bank where you could have hanged her? She has committed misconduct. But where is the proportional? Why dismissal? They have not come, go home. That would have been sufficient. Why to carry the stigma of dismissal?
No, the stigma is not there.
Then
But the order is my lord.
What the order is there?
No stigma is there.
Huh?
No stigma is there.
No stigma is there.
No.
But he says dismissal. Dismissal is a stigma.
No, it will not.
Removal.
Removal from service which shall not be
shall not
disqualification from future employment.
That word is there.
Yeah,
So that means it was not any stigma.
No, you said the dismissal.
No, removal from service. Sorry.
Then they
removal from service which shall not be
It
disqualification
is not a stigma.
from future.
Non-stigmatic. Removal simplicity. You can get
Compensatory pension I can be some benefit because I at this stage I cannot seek any of the further employment. And if there is some relaxation, disproportionate, compulsory compulsion pension, madam, so that I can survive in future. Yes, sir.
How?
Compensatory pension.
Pension. Yes. On what ground? You were joined the service on 26/5, 2011. You were removed on 30/4/2011, which falls short of 10 years. Then without
compensatory pension, compensatory pension can be granted.
How? Where is that point? Show that.
Compensatory pension.
Sure.
Even within less than 10 years.
No, it cannot.
Qualifying service is 10 years.
If qualifying service is not complied, 1 day less, the other person will come. For 1 day you have given pension, mine is 2 days, give us pension. Yet another person will come, mine is 3 days. It goes on like this, 4 days, 5 days, 1 year. Then 1 day. To him also we have to direct pension. That's not the policy of the, that's the policy matter. Where court cannot run a race of competition with the executive.
No, not policy. I am not saying.
We cannot. And it's not a dismissal. Since you say dismissal, we were assuming that dismissal is a very disproportionate, very not proportionality rule is violated. But even that is not now. Because it's a removal simplicity. And they have made it clear. It will not be a disqualification for any other employment.
That's very removal. So only sort of some days from 10 years.
No, that it is like 3-year period for filing the suit.
Yes,
only 2 days more. Can they give it?
Let the bank consider for some lesser punishment, my lord.
What lesser? How? What is? Tell which is the lesser punishment.
Some increments may be stuck.
No, now you said you are not in a position to work also.
No, I am position.
No, you said then you go for work elsewhere.
Also, I cannot get my lord. I may not get my lord. I may not get a fresh job. At this age, my lord. At this age, I will not get any fresh job.
But it's a swayam krita aparadham. Your own wrong it is. You should have gone. At least you should have said, my brother is not in this. You are not. Your conduct does not satisfy the required moral standards on which Article 226 and Article 227 are built. The moral standards are inbuilt now because of apex condition, constitutional morality. Nothing.
Some increments may be 2-3 increments, some lesser punishment. I can survive, my lord. So that is fresh, my lord.
Where have you stated job is the only source of livelihood? Sure. If that were to be so, how could you survive all these years since 2011? No, either way you don't have.
So something relevant in service.
In 2021 till 2021, 5 years already there.
21 I am suffering, my lord.
Now, where have you taken up a contention? This job only source of livelihood. If you take out that job, it amounts to taking out the means of livelihood. Therefore, Olga Telis will come in. No such structure.
That part, my lord.
That is not your case at all. Even in your representation, you are not indicated. Don't harm me. This job is the only source on which I eke out my livelihood. That is also not your case. You cannot make a totally new case in your
not
petition.
making that. I have taken that down, only disproportionate down. Others, some lesser punishment, that is, I also, at the end of the report, my lord, I then also suggesting that, my lord. Any lesser punishment can survive.
This is a what learned Cibil judge said?
Confirm the order of dismissal. The appellate authority says the inquiry was conducted within 1 hour and concluded within 1 hour. The law says, my lord, I should have given some chance, my lord, at least 30 days you are adjournment. That is what for? That is the law, my lord. That is the
Where you stated, since shortest, did you seek a longer date?
Yes, my.
Where is that?
No. The regulation says, my lord, 6.
That's all right. Did you seek? You have given only 1 day, not sufficient to me. They have held 1 day, but you were given opportunity.
No, I have given, my lord, that was opportunity. Since I denied the allegations, my lord, the moment I denied the allegation.
What was the allegation?
The charge memo. Allegation is charge memo.
Is what?
Charge memo, honest absence, my lord.
No, write-ups.
Honest absence.
That's all. What other things to be done in that?
This talking census, my lord. I denied the way of forced me to remain honest, my lord, absent, my lord. I waited for your decision on my representation regarding on the circular, my lord, the benefit to extend the circular, my lord. That is the inquiry. The date is fixed for preliminary inquiry, my lord. I denied the allegation, my lord.
Not preliminary inquiry. Preliminary inquiry in service jurisprudence does not include the delinquent employee at all. Only it is a preliminary inquiry. Whatever word they might have used, if your participation is there, it partakes the character of a regular inquiry.
But the inquiry date was fixed for preliminary inquiry.
No, they might have said preliminary inquiry. If inquiry notice is sent to you, it ceases to be preliminary inquiry. It partakes the character of a regular inquiry. Because in service law, preliminary inquiry is held ex parte the delinquent employee on our own, whether main inquiry should be held or not. That is not the case.
Since on the preliminary inquiry, my lord, they asked me whether I am guilty or not. I denied, my lord.
Once an inquiry.
Yes, my lord. That is page 30, my lord. Page 30, order sheet preliminary inquiry. And there are rule 6, my lord. That's rule 6 itself there.
There is nothing.
That's rule 6, my sir. If the officer employee does not plead guilty, the inquiring authority shall adjourn the case, my lord, to a later date not exceeding 30 days or within such extended time as may be granted by the inquiring authority.
Whether there was a intra-departmental abuse? Any appeal?
Yes, I have before the appeal. The appeal authority also.
Did you take up that contention?
Yes, I have taken that down, my lord. And
how you have taken that?
And the appellate authority also admitted that, my lord.
No, what prejudice is caused to you by that? That you have to show. Rule might have been violated. Two things. You have to show that rule itself is mandatory. Or violation of the rule has resulted into prejudice to me. That ground you have to
I have
show.
stated that in page 54, my lord.
50?
54, the appeal memo, my lord. My appeal memo is page starts from page 13, my lord. Page 53, annex 13.
See, that the entire proceeding of the farcical inquiry was concluded within a couple of hours. You said 1 hour. They have said couple of hours. In a single day. In a fully partisan, these are all lawyers' words. But couple of hours the inquiry has been held. How many days the inquiry should be held? It's a question of remaining unauthorizedly absent. Why, how many days sitting?
Actually, it was
Why?
to prepare my documents, my lord.
You said I have to look after my parent. That did not agree, and you have not disclosed everything. Even here you have not disclosed in your petition. You means your client has not disclosed. In fact, learned single judge should have asked the question to you. Anyway, the single judge said
My lord,
followed.
only on that ground, my lord, on proportionality, some lesser punishment I will bear. Some lesser punishment so that he can survive, my lord. Lady, unmarried lady.
No, unmarried all right. Unmarried maybe she can be as a rich queen of Virginia.
For taking care of her father, she remained. And some lesser punishment
of God.
Lordship, let them consider for some lesser punishment, my lord.
No, not possible.
Let the bank consider it, my lord. Say, leave it to the bank, let the bank consider it, my lord.
No, Apex Court said not reporting for a place at the transferred place itself is a major misconduct. Take up that judgment. Not reporting to the new place pursuant to transfer orders. It breeds indiscipline. This is how Apex Court has said in two has said like that.
Yes, my lord, here distinguishable, my lord. Because I applied for to exempt me in view of the as for the.
What do you say?
But not the argument advance regarding the one couple of hours, my lords. That is taken care by the Honorable Single Judge. With the factual scenario already discussed in the foregoing paragraphs, it is settled that the petitioner was specifically asked during the course of inquiry with respect to examination of witness and production of documents to adduce evidence, but she declined. It is fact on record that an application letter to this effect was also submitted by the petitioner, which closes all possibilities of affording further opportunity. This court is satisfied that there was substantial compliance of provisions of the regulation 1976.
You declined to examine any of the witnesses.
I was the sole witness. No outside witnesses, madam. That means I was ready to give, I was examined myself as sole witness, madam. There was no other witness for me.
You were examined.
I stated that, madam. I was no other witnesses. I would have been examined as a sole witness for me, madam. That was the he interpreted it differently, madam. I was a sole witness for me. For on that ground, let the bank consider, sir. Bank will consider some lesser punishment, so I can see.
And as far as dependents are concerned, my lords, they will have to declare, an employee has to declare that they are dependent because the other benefits they will get.
Correct.
That this is the circular posting of employees who have differently able dependents, and it was taken care, my lords, in the appeal. Moreover, after going through her records and HRMS data, it is observed that Ms. Nath has never declared her father as her dependent.
Yes, sir.
Yes, my lords. And one brother is a doctor. She herself has deposed before the.
I disclosed her brother is doctor. No, he is not taking
and she
care.
was also. He was also in.
No, that you have not said.
I have not said that.
You have not said that. Because your brother would have sued you for defamation. You have not said that. Thank you.
Just leave it to bank, my lord. Leave it to bank. Let them consider it.
This intra-court appeal by a dismissed bank official seeks to call in question. Repetition move.
Remove. They call it dismissal. Remove.
Whatever it is. This intra-court appeal by a removed delinquent bank official seeks to call in question a learned single judge's judgment dated 11/9/2024, whereby her WPC 5688 of 2022 has been negative. First, in the said petition, she had laid a challenge to the removal order dated 34/2000. No.
Yes,
removal order dated
30th April 2021.
21. And you did not challenge appellate order.
Yes, both.
And the appellate order dated
27/1/22.
27/1/2022. First one. Next paragraph. Kindly be seen. Learned counsel for the petitioner vehemently urged the following grounds for voiding of the impugned order. A. The appellant was disabled from reporting to Godhra branch of the bank from
Godhra region.
Godhra region of the bank from Cuttack region pursuant to transfer order dated
Cuttack under Bhubaneswar region.
Bhubaneswar region pursuant to transfer order dated 29/6/2019. Correct? Well, 29/6/2019, in as much as she had to look after her aged and ailing parents who had none else to do it. B. The inquiry was farcically held with no due opportunity of participation, and therefore there is violation of principles of natural justice. C. Even otherwise, the removal from service is an extreme penalty, job being the only source of livelihood, and therefore the impugned orders, namely the removal and its affirmation in appeal, and their affirmation in the learned single judge's order, spurned the doctrine of proportionality. First. Next point. Learned panel counsel appearing for the respondent's bank resists the appeal, making submission in justification of the impugned order and the reasons on which the same has been structured. First, he contends that an intra-court appeal of the kind has got its own limitation, and therefore a deeper examination of the findings of the disciplinary authority, as affirmed by the appellate authority, and also as have secured imprimatur at the hands of the learned single judge, cannot be undertaken in this limited jurisdiction. First answer. Lastly, he tells us that the moral standards inbuilt in Article 226 and 227 of the Constitution of India for invoking writ jurisdiction have not been satisfied by the conduct and demeanor of the appellant, and therefore she cannot be shown leniency in matters like this. First one. Lastly, it tells us that once the finding as to the guilt is recorded in a duly constituted inquiry, the court will not enter the domain of punishment, which exclusively is of the disciplinary authority. First, next, having heard learned counsel for the parties and having perused the appeal papers, we decline indulgence in the matter, broadly agreeing with the submissions made on behalf of the respondent bank with our comments as at. One, the appellant joined the service of the respondent bank as junior management scale 1 officer with effect from 26/5/2011. First, all through she had been working in Cuttack branch and she was issued
Cuttack and Bhubaneswar
in Bhubaneswar region, only in Bhubaneswar region. First, a transfer order dated 29/6/2019, shifting her from Cuttack to Godhra region was issued, which she did not abide by. First, she also remained absent unauthorizedly for quite a long period, eventually resulting into institution of disciplinary proceedings. With her participation and full opportunity of hearing. First one, the only allegation being unauthorized absence, such a disciplinary proceedings cannot be long drawn. First one, therefore, the first contention that the proceedings were hastily completed does not merit acceptance. Added reason being the absence of demonstrable prejudice by the arguable haste. First, next point. The second contention that the petitioner had moral justification to stay away from the duty as she was looking after her aged parents is a bit difficult to countenance, even if it is factually assumed to be true. First, reasons for this are not far to seek. Firstly, the appellant did not disclose that she has an elder sister who is married away and a doctor brother who has distanced himself from his spouse. First one, if there is absolutely no reason to assume that when an estranged person in marriage, that too a medical practitioner, is there as a son, the daughter would be required to look after the aged parents. There being nothing in the representation made by the appellant to the management seeking a retention and continuation in Bhubaneswar region itself. First one, there is a moral culpability attributable to the appellant in as much as she never disclosed as to there being a married sister and married but estranged doctor brother in her representation to the management, nor in her departmental appeal, nor in the writ petition. Even in writ petition, it has not been stated. Writ petition. First off, no explanation is furnished as to why this suppressio veri has been committed. First off, a person who does not approach the court with clean hands, clean head, and clean heart is not entitled to invoke the constitutional jurisdiction of the courts. Next point. The next contention of the counsel for the appellant that his client did not have full opportunity of hearing in as much as her version was not fully allowed to be put to is bit difficult to countenance. First, the inquiry records disclose that the appellant was specifically asked as to whether she intended to examine any witnesses on her side. And she answered it in the negative. First, the related contention that a delinquent may not examine other witnesses, but he or she himself can examine as a witness, and that opportunity was not given, is a too far-fetched a submission. First off, merely saying that opportunity was not given would not suffice in the absence of demonstrable prejudice that has been occasioned to a person by the arguable breach of natural justice. First off, the violation of principles of natural justice cannot be chanted like mantra. First off. Next one, the last contention of the learned counsel for the appellant that the punishment of removal from service is too harsh and that he has nothing to fall back upon except the job in question, again is liable to be rejected. Firstly, the appellant has never disclosed anything as to the job being the only source of livelihood in her representation, nor in her submission before the disciplinary authority, nor before the appellate authority, nor before the learned single judge. First of all, such a contention cannot be taken without laying the foundational pleadings therefore. First off, not last contention, now last contention. The last contention that the punishment of removal is disproportionate to the gravity of the offense, again, not acceptable to us. First of all, ordinarily, the employees in public employment are expected to join the places pursuant to transfer orders, save by exceptions. First off, no case of exception is made out, and therefore we cannot agree with the said contention. Added, once an inquiry is properly held and the disciplinary authority hands the punishment with the participation of the employee, delinquent employee, comma, all that falls within the domain of the employer and the writ court cannot, subject to exceptions, interfere with the same. First, to put it shortly, what punishment should be awarded to a delinquent employee whose guilt is proven is essentially a matter for the disciplinary authority stroke the employer. First, not complying with the transfer order would create many problems in banking organizations of the kind. Okay. First, after all, the bank has only issued an order of removal simpliciter as contradistinguished from dismissal. First, it is thus a non-stigmatic removal. First, in the above circumstances, appeal being devoid of merits is liable to be dismissed, and accordingly it is first having been made easy.
Pardon, Milon, item number 140 of the weekly list, state appeal, accommodated in the supplemental list because the contempt is posted to Friday, Milord, directing personal appearance. 140.
Item 38. Next item 41. Well, that has not been admitted. That should come under the heading of case admission. It has come under the heading.
Which one?
Item 41, my last item.
41?
That has not even admitted, my lord.
Not admitted?
Yes, my lord. Only delay has been condoned. And I am told the respondent, my lord, since 2016, I have deprived from getting my legitimate salary.
Why it is for hearing not yet admitted?
It is not admitted.
But when it is in the heading of
same is 30. Record C. If it is not admitted, then you shift it to admission.
Same is 38, my lord. Same 38.
38 also.
Yes, only delay has been condoned, state appeal.
Well, may I for next week, man?
It will come.
Item 39, my lord. Sole petitioner proprietor had died. I have filed substitution petition that may be allowed. Soft copy, substitution petition within time.
Serial number?
Serial number 39.
Is it other when he died? Which is the date?
Date, my lord. He died on.
And when the application is made?
Application within 30 days been filed.
Within 90 days?
Died on 30th of January. And you made application.
We have made application. The petitioner.
Operator of the petitioner for what? First petitioner first. Proprietor of the first petitioner having passed away on
30th of January.
January 2027.
26, comma. This application in IA number so and so supported by affidavit has been filed to bring his LRs on record. First aspect. Application is in form and filed within time. First up. No objections are filed. No objections are filed to the same. First up. There is a prima facie case made out for bringing the LRs of the deceased proprietor on record so that the legal battle can continue. First up, in the above circumstances, application having been favored, leave is accorded to the LRs of the deceased to come on record. First up, petitioner to amend the first immediate. Entry order is there. Entry order to come.
Well, date we fixed for here.
Which year matter?
26.
26.
No, 25.
25.
But bank
third week of May.
Record.